Oh, they're like service. It's like wouldn't send a message. Did it come through?
It just came through, but my phone was acting funny, so I restarted it. And then it came through.
Yes. Got heard. Thinking it's going to start taking you time. He's been for a long time.
A long time.
Yeah. How much? So I just really round it and execute it. And then for him, I'm thinking 3P.
Okay. Okay. Perfect. Thank you.
Morning. What's your name? What's your name?
Stanley Ross.
Stanley Ross.
Mr. Roberts is represented by Keratin Matthews, so he'll be waiting for a little while till his lawyer shows up.
Thank you, Judge.
You bet.
He's lying, but he's not hit the little bit. I wish my application's done with the calendar still. That's why. No, it's not even on the calendar. And it wasn't just, it was judge. Yeah. So I was like, no, because he has another case that needs to get indicted. Probably because he needs to get. So nothing's happening with him today.
That works. Okay. That's all.
So I think all we have to go is, Miss Edwards. Her. Which one is this? Ron Edwards. She. Yes, she.
Oh. Rotating that.
I went to.
Probably,
I can't remember before.
I think Wright Street. I think.
Yeah, but she was at Wright Street when I saw her, but she wasn't separated from anything.
Thought they did, that's why.
Yeah, they should be.
Do they? Because I've had several.
Are you on? I don't have
Oh.
my computer, but I looked it up because I remember that person from when Lee had them.
Yes.
Oh, okay. I was like, who? Yes. He keeps calling me and I'm like, really? Yeah, he's literally been calling me and leaving voicemails and sending the photos, so.
All right, let's get started with what we can. I know Deputy Gordon is moving some folks around. We have a guest court reporter this morning. Ms. Hicks, can you hear me?
Yes, Your Honor.
Great. I'll let you know when you need to take stuff down. We've got a calendar that starts now. We've got another at 1:30, but there may be a bunch of back and forth that you don't need to take down. So you're welcome to do whatever you want, but I promise I'll let you know when I need us to be on the record that you'll be creating.
Thank you.
Sure. Thank you for being here. All right. For the morning, we have a plea and arraignment calendar. Position 1 is Dion Stafford. Don't see him.
So, good morning.
Good morning.
I had him, or I had requested Ms. Nelson add him to this calendar. He was actually with the Department of Corrections, and I was thinking he would have been brought to the jail, but he was released. So,
Okay.
I'm working through trying to find a good contact for him.
Got it. So his notice would have been we produced him, not that he got something in the mail.
I think that's correct.
Did you open the courtroom doors?
I don't know. People are coming in.
Oh, are they on?
I think they're locked, but I don't know. If
Oh,
it's
that's what, do you want to call the counter?
Okay,
I mean, if you want me to open it, I will open it.
that'd be great.
Okay.
Thank you.
Judge, I'll double check on that.
Okay.
He didn't I think the reason I was courting Nelson is I don't think there was a bond, so that's why I was thinking he'd be brought back to Wright Street.
Right, although on the calendar, it lists a $15,000 bond. It doesn't mean that's what's in Odyssey, but something pops up in that way. It's an old arrest, but new indictment.
And it's something that I was expecting to work out, so if we can.
Okay, so we just need to track him down.
Yes.
Thank you, Ms. Nelson. Yeah, everything is from way back in September of 23. Okay, he did get a bond from Judge Manning in November of 23, a $15,000 bond. That's what's on the calendar. I don't know that he's made that bond. It doesn't look like it, but there is a bond out there. It sounds like we ought to reset it. Maybe, we'll see. So you have communicated with him, but it was because he was in DOC?
I've not communicated with him. When I was researching he was originally on a different calendar and he was actually serving the sentence in the Department of Corrections.
Okay.
So then we just pushed it out.
Okay.
Because I was thinking he'd be brought back.
Got it. Okay. Well, there is an address in the system, so I guess we could reset this one cycle of notice and see what happens. All right. Dontrellis Polland, Ms. Rios, I got word that you filed a waiver, but you were expecting him to be here, or because I have notes that people were excused. He's not listed as excused, but.
He's in jail.
Yeah.
Okay, so he'll be here.
Yes.
Okay, great.
And just.
I can't tell because it says bond on here. I didn't know. Oh, it also lists the booking number. When he's up, we'll talk with him.
Okay.
Okay. How about Gavarius Hill?
Judge, he'll be mine if he shows up.
Okay. We will call his name again. This was in one of these great non-complex transfers. All right. Ethan Brown has 2 cases, a whole lot of entering auto counts. You filed a waiver, Ms. Wood, and he was excused. Okay. In looking either Ms. Dilligard or Ms. Wood at these 2 cases, one, it looks like the arrest was in 2023. I'm just wondering if this is one where he really shouldn't be out on bond. Like he was on bond for one and then he picked up more charges and yet there were no bond consequences. I don't know if you all have poked around in the file at all.
I haven't yet because we're working towards a global resolution that I anticipate will include some sort of time.
Okay.
So
Global as to the 2 cases, or does he have
There's-
yet more?
I think there's another one.
Let's see. I think he has 2 entering autos. So we should.
On the calendar, it's 2, I mean, it's like 1 million entering autos, but it's 2 indictments.
Right. That's the only ones I'm aware of.
There's 2 unindicted PI cases.
Okay.
So yes,
Do you have those PI numbers?
yes, it's 24 PI 000369
Okay.
and then 24 PI 008226.
All right. It is remarkable. He is out on bond, but we'll work through that. Okay, but Mr. Brown doesn't need to be here today. So that one is taken care of. Brandon Shavas.
Judge, I have one of his cases. Which one is on this calendar, though?
Yeah, so do you
What's
think
the
you have
case
Mr.
number that's on
Shavas?
the calendar?
Pardon me?
I have him for a case. I have him for the one that ends in 419. The one that ends in
Okay.
0891,
Yeah.
I don't have yet.
Okay, but do you think Ms. Steffel had it before? And I know she tends not to carry cases over from pre-indictment. So do you think you will get Mr. Shavas get his 891 as well?
Yeah, I think so. It doesn't make sense that it wouldn't come to me because I have the other one that ends in 419.
Right.
So I can't imagine that they won't send it to me. They just haven't yet.
Got it. Okay, I follow that. Yeah, they're similar sounding cases. Oddly, they have the same booking number, but I guess different arrest dates. So is Mr. Shavas on bond?
He was here, Judge, for an inquiry calendar earlier this month. I can't remember though if he was excused.
Yeah, he was there 410.
Yes.
Okay.
I don't know if he was excused from this arraignment calendar. And at that time, I didn't even know that there was another case coming.
Yeah, he was not excused for today.
Okay.
Maybe he's this iPhone. Are you Mr. Shavas? Nope. Okay. Well, Ms. Cabrera, if you've got contact info for him, if he could appear on the Zoom call or come on in, that would be a good way for us to start this process.
I am looking right now and I do not have any phone numbers for him.
Okay. Let me look him up also. And
Yeah, nothing I have comes with a phone number. I have his address, but no phone number.
okay. Wow, that's a lot of counts. So I've got 3 phone numbers. I guess I'll put them in the chat to you.
Okay.
So the first one is supposedly dad. The second one, I should have written this on there, is grandmother. And the last one, in theory, is his. I haven't sent you that.
Okay. Yep, I'm recording them. And I guess for him, assuming he appears or I can get in touch with him, then I'd enter a plea of not guilty and waive formal arraignment and just ask for 10 days after I receive discovery to file any motion, assuming he appears.
Right. Assuming he appears and you don't have to worry about the 10 days, there'll be a scheduling order that will have a motions deadline that is after the discovery deadline.
Okay.
So if you would try those numbers and then let me know what, if anything, you get from, again, that's dad, grandma, and then I'm assuming his own number. But this was from when he was booked in a minute ago. So maybe one of them will still work.
Okay. I think I still have 2 other people on the calendar. So once I get through those, then I'll go on ahead and sign off so that I can reach out to him.
Sounds good. Thank you. All right. So that gets us to Mr. Francis's client, Mr. Davis. but I have here that Mr. Francis did a waiver and that Mr. Davis and Mr. Francis were excused. But maybe Mr. Francis has other cases. Oh, and
I
he's
think
dropped. He was
Yeah, I
on
think
briefly.
he was on, but I think that's the only thing that he had.
Okay, so, and this is a co-defendant of Mr. Shavas in the case you haven't had assigned to you yet.
Okay.
All right, so that takes care of that.
Make a quick announcement on position 6.
Okay.
We had a gang and theft case that was indicted yesterday by A.J. Hiles.
Great, so that'll come here.
Well, he green sheeted because to Ingram, because the co-defendant on that case had the order.
Ooh.
So I didn't know what would happen, but I just wanted to make the call fair.
All right. I'll share that with Ms. Nelson to see if this whole hairball with Brown and Shavas comes tumbling to 70. Yeah. Do you happen to have the Mr. Hiles's kid? It's one of the few good things he's ever done for me. If this works in a transfer.
It was indicted yesterday morning, so I'm gonna see if it has an SC number.
That's okay. Mr. Davis is in it. That we can look through him. Yeah. Okay. Yeah, it's a unique first name, so he'll be findable. We'll see. I'm not a big let's throw everything that could follow, but if Mr. Davis has at least Mr. Davis's stuff should go. So I don't know if that will have the ripple effect of pulling that one. Shavas and Brown have a standalone. We'll see, but this would need to go. Well, April. Thank you for that update. So number 9, Reynolds Cowlin. Ms. Beskin filed a waiver. I don't have notes that Mr. Cowlin was excused. But we can come back to that. Then we've got Ethan Brown again, but he was excused. And Mr. Shavas, Ms. Cabrera is going to check on him. We get to Frederick Avery. He was excused. There's a waiver filed. Lorenzo Harris Brown.
That one is assigned to me, Judge. That's a new assignment to me.
Great.
I don't know where he is though. When they send me information, it doesn't tell me anything about their placement. So.
Got it. He's got a booking number, so he's here? Okay. So we'll bring him out in just a minute. I guess we'll get through the calendar. Deputy Gordon's out here now. And you can bring people to the door still, or not even to the door? Okay, all right. We're working with one deputy right now, so we're down a little bit. And next up is Stephen Gomez, transferred from Judge Cox because of our much older open case that's on the trial calendar. Mr. Gomez is your client on both those cases. Today we'll just do an arraignment.
Right, and he has the other cases actually on your calendar for the 8th.
Yeah, it's on the
trial calendar.
Yes.
Yeah, for the other case. So I guess are both these cases Ms. Dilligard's?
Yes.
Okay. So I just need to speak to Ms. Dilligard to figure out if there's a way we can resolve him. He was the one that had the evaluation that's returned.
Right.
Now we just need to figure out what to do with both of the cases.
Right. No, I remember Mr. Gomez. I think this was pre-Dilligard, but he introduced himself as a federal agent and was working for us on the inside.
Yep.
And now he's working with you.
Yep.
Very, very affable guy. Just he maybe is seeing things I'm not seeing, but that's all right.
Right.
Position 13 is Mr. Roberts. Mr. Roberts is here. Good morning, Mr. Roberts. Your lawyer let us know that he's got a couple other places he needs to be, but he knows he needs to come by here this morning as well. So you need to sit tight till we get Mr. Matthews or one of the associates from his office here. Okay? And then we have Darian Kirkandall, and we weren't sure how that was going to play out.
Going to be here. He's driving from the airport now. He said 10 minutes.
He managed to fly here.
Yep.
Okay. Huh. All right. We'll hold for his report. Well, let's go back through this. We'll reset position 1 for notice. He was released. Dontrellis Polland, is he here? Okay. Let's bring Mr. Polland to the door, please. Oh, position 1 is here?
Yes.
Oh, well, let's bring him to the door.
No.
Oh, are you Mr. Stafford? Yes, sir. Oh, let's deal with Mr. Stafford first, then we'll get Mr. Polland. Sorry, how'd you get notice to be here? It's great that you're here. And you recently got released. Congratulations.
Came to my auntie house.
Okay. Well, I don't mean to sound so surprised that you're here. It's great. I'm Judge McBurney. Your case has been assigned to my division. And you are going to be working with Ms. Wood, who is standing behind you. And let me see a little bit about your case. So Ms. Wood had learned that you were in GDC custody and actually had tried to arrange that maybe we could get you virtually from wherever you were, because she thought this particular case, which is old, might be resolvable. It may still be, hopefully it's resolvable. It just may not be today, but it could be. Ms. Wood's probably going to want to talk to you about that. You're charged with burglary from 2023. Ms. Wood, do you want to chat with Mr. Stafford after we get through a few other folks? Okay. Then let me confirm a couple of pieces of information about you, and then I'll let you and Ms. Wood talk, and then we'll talk as a group again. I've got an address for you of Blair Villa Drive.
No, I'm at 30.
I'm gonna let you, don't need to put it, we'll get it, there's a piece of paper you're gonna fill out with a new address.
Yes, sir.
Okay, and then Ms. Wood is gonna ask you for your contact info, if you've got a cell phone, email, just so you and she can stay in touch, and she'll give you hers. After you guys share that info and she tells you a little bit more about the case, we'll talk again this morning, okay? So you can take a seat back there and we'll wrap it up.
Thank you, Judge.
Thank you. All right. So Mr. Polland, if we can bring Mr. Polland to them. And is Mr. Polland, he's in on new charges, it looks like. He has a more recent booking number.
The probation revocation that doesn't have an assigned court date. It was an no judgment on it.
Okay. All right.
But it's a whole month.
Hey, Mr. Polland. No, you're good right there. You're good right there. We're just only able to take folks to the door this morning. Good morning. I'm all right. I'm Judge McBurney. Your case has been assigned to me, and Ms. Rios, who is seated right there and just looked at you, is the lawyer who will be helping you with your case. She has already filed what we call a waiver of arraignment, which means she entered a plea of not guilty for you. She will soon get the discovery in your case and then work with you on what's in there and figure out, is this a case that maybe could be resolved with a plea? Should it be dismissed? Should it be a trial? She'll talk with you about that. You had a more recent arrest. Do you have another case or?
Yeah, dismissed. February 31st.
Okay, all right. Dismissed because an officer didn't show up or?
Well, he charged me with drugs, but I didn't have the drugs on me.
Okay, got dismissed either way. Do you have a probation situation?
Yes, these charges is how I violated my probation.
Okay, got it. I think that's with it.
I was paying my dues and I was reporting, I was doing everything. I had got stabbed up and I got stabbed in one of my eyes.
Gotcha.
I was trying to get disability, and in the process of me getting disability, it had been 2 years and I had got denied. And once I got denied, I got frustrated and I relapsed.
Okay. Well, I don't want you to talk a whole lot about your case right now. There will be a time where I'm going to be real interested, and I'm interested now, but it will be important for you to tell me more about your situation and the relapse. That's not this morning. But I think Ms. Rios will want to talk to you about that revocation and this, and whether something like drug court might make sense if you're still wrestling with some addiction issues. But this isn't the time that we'll work through that. I just wanted to introduce myself, let you know that Ms. Rios is working on trying to pull together the different pieces that you're working through. Your revocation, your probation situation is with a different judge, and that can get a little confusing sometimes, but often the judges try to consolidate things. And so it may be that your revocation comes here for me to work through. If you'd like to.
The last time I was in court, Judge Williams, my probation judge, she said, due to the fact that you got my case, she was gonna let you deal with probation.
Well, there you go. That's what I mean about things being consolidated. So if she's okay with that, that's going to help Ms. Rios figure out with you what's going to happen next. So she will come see you. She's going to get, like I said, the discovery, all the paperwork in this case, and then you guys can figure out how you want to move forward.
I'm going on the other case, and I've been locked up 4 months.
Okay. All right. So,
I mean, like,
Mr. I'm gonna talk, you remember how I'm trying to look for a program and to wrap everything together? Once I have a place for you to go, then I'll let them know.
I'm saying I can go to, I'm report, because I mean, I've been locked up 4 months.
I get it.
So Mr. Polland, let me help you through one process, and then I promise we will have a conversation where you don't have to stand at the doorway there. You can be sitting at the table, et cetera. It could well be, so you need to have a revocation hearing. It sounds like that will be with me. But I could decide that as a result of these new charges coming while you were on probation for something else, that I ought to revoke 6 months or a year. So you're not spinning your wheels right now. You're earning good time towards whatever the revocation might be. Hearing you describe what was some of the struggles you were having makes me think that we ought to be focused on getting you some support so that when you're released, if you continue to struggle to get benefits, you don't get frustrated and relapse again.
I had stayed clean like a year and a half. It was just, I was struggling trying to get my disability, and I got frustrated. But like, since I've been locked up, they've been calling my mom's house where I was staying at, and they've been trying to interview me.
To finally get you the benefits. Okay, so then we need to get you reconnected with them. All right, so Ms. Rios will talk with you, and we don't need to wait a long time. It could be that she says, Judge, we're ready to go. Let's get Mr. Polland in here next week. I don't have any of the information about your case with Judge Williams. So that's not something that I can do today. And it's not because I want to move slowly on this, but the prosecutor, who's in here as well, is entitled to know about that other case. Ms. Rios needs to get it. That's not a complicated process. Like I said, it could be that we try to get you in here next week. But Ms. Rios needs to process all that so she's able to advocate for you effectively. Okay? Let me ask this. When you get out, do you have a safe place and a stable place to stay, or is housing one of the things that you need help with?
Well, I can stay with my mom. She retired.
Okay. Does your mom say you can stay with her, or do you say you can stay?
Probation not to. But I would like to have my own place.
Okay.
That's why I was.
The benefits would help you get your own place. But your mother.
That'll like kill the burdens of a lot of stuff that I struggle with.
Sure. Okay. But what you're saying is that your mother's home is a place you could go to?
Always.
Always. Okay. And is she in the metro Atlanta area?
Yes, sir.
The address that I have for you, there are two. One is an apartment on Sells Avenue.
This is my dad.
Okay. And then there's a Carroll Avenue address.
That's a whole.
Okay. So we don't have your mom's address. We don't need it right now.
My mom's address is 207.
We don't worry. We'll get it. If that's where you're going to be, I promise you're going to fill out some paper saying, here's where I'm going to be. What address do you think probation would have for you?
They would have a wrong address. I mean, when I started probation, that's why
At your mom's?
Yes.
Okay, all right. Do you have any other questions?
When I'm coming back.
Okay, the fair question. Let Ms. Rios talk to you about that. She needs to get all the paperwork for this case and the situation with Judge Williams, and she'll talk with you about it. And she knows how to get you back on a calendar in here so we can see what we can work through. Okay? Thank you, Mr. Polland. Ms. Rios, I guess we wait on updating the address. We'd just get that when he's released.
Okay.
Oh, he said the basis for the warrant were these new charges.
In addition.
In addition, so there's a technical violation of moving without, and then a serious violation of new charges. Okay.
And his unindicted case was dismissed at prelim due to no officer show.
Okay. That's what I get. I mean, that's not what I gathered from him. He has his own view about why it ought to be dismissed, but I get it. Okay. So you've done the waiver, Ms. Rios. We'll do a scheduling order, and it sounds like you're going to be engaging Ms. Ross.
We did a social work request. She should be up. She should have already seen him or probably.
Okay. And think about drug court as well. Whatever is the right fit, and he seems to think treatment isn't the big need. Certainly benefits will help if he is able to plug in with SSDI. All right. Last call for Gavarius Hill. We'll do a bench warrant. We talked about Brown. Ms. Cabrera, did you try to connect with Mr. Shavas?
Yes, he said he'll be there at 10 o'clock.
Oh, as in walk through the door?
Yeah, he should be walking through the door at 10 o'clock. He's on his way. So yeah, none of those numbers are really him, but I do have him now. So,
You just dial a random number and he picked up the phone?
no, so I sent a message to one place, but he called me from a different number.
Got it. So one of those is dad or grandma who then said, got it.
Yeah, one of those numbers does work, but he texted me himself. He said from a different number, he says he is on his way. I asked him how long, and he said 10 o'clock.
Okay. Are you able to be with us at 10, or should I just let him know since he's got your contact information that you were here?
If you could do that, that would be great. I have a calendar right at 10 o'clock. I have one at 9:30. I asked him to hold for me. And then I have another one at 10 o'clock with two different clients.
Okay. Well, why don't we, since you got to go, jump to your other cases on here, and then we'll bend back to the others. So Lorenzo Harris Brown. Oh, he's here. Okay. We're going to bring him there. Can you move that screen, the camera, just so Ms. Cabrera can see?
Yeah, I can see him. Mm-hmm.
All right, let me do that. And that. All right. Good morning, Mr. Harris Brown. Sorry you're having to stand there and they're making you hold your lunch. Okay, sorry about that. Normally we'd get you over here, but we only have one deputy right now. Ms. Cabrera is on that screen. She's your lawyer. She's been appointed to represent you in this case. You're charged with fleeing or attempting to elude and reckless driving. It's from way back when. It's from in November of 23. But it was recently indicted by the Fulton DA's office by a grand jury and assigned to me. Ms. Cabrera and you will be working through the charges and we'll be figuring out what's next. I think you've got a new case as well. You got arrested for something else recently? Okay. That has not been indicted yet. So Ms. Cabrera may want to try to resolve both cases. Let me look up your new charges. All right, it's the allegation is you had a gun as a first offender probationer and a misdemeanor amount of marijuana. So you had a lawyer who just yesterday, did you have court
Yes, I have, but they didn't come get me, so they rescheduled.
Okay, a lawyer and you signed it. So Sydney Gibson and you signed something waiving your preliminary hearing. So you don't have to worry about having a preliminary hearing. And now I guess you will wait on the state to either indict the case or, like I was about to say, Ms. Cabrera may work with the prosecutor to say, let's wrap all this into one. Try to see if we can resolve everything together. Ms. Cabrera, are you waiving arraignment on Mr. Harris Brown's behalf?
I am, Your Honor.
So all that means, Mr. Harris Brown, is that Ms. Cabrera is going to fill out a piece of paper that enters a plea of not guilty, not to the gun case, but to this fleeing or attempting to elude case. I'll enter a scheduling order, and that'll get the prosecutor to give discovery, the police report, stuff like that, to Ms. Cabrera, and then she can start meeting with you to figure out, hey, is there a way to resolve this stuff, or what are we going to do? I will see you again either because things have been worked out or because Ms. Cabrera has filed some motion on your behalf that we need to work through here in court. Okay? Do you have any questions about anything?
So is she going all that together, like her, BOP?
Yeah, he has a warrant, I was going to say that.
Oh, you got a warrant too, because he's a first offender probationer?
Yes, he was in charge of him.
Oh, Douglas County charges too. Okay.
That's what caused the BOP.
Yeah.
Got it. Okay. The case for which he's on probation, is that a Fulton case? And whose case is that?
Actually, that one,
Do you have the case number?
I do.
What's that?
It's 23 SC 190090.
Let's look it up. Do you have probation from Douglas also, or just you have new charges in Douglas?
Oh, okay.
2 misdemeanors,
Okay.
terrorist and reckless conduct.
Okay, here you are. It's Judge McAfee has your case that's on probation. And you, in May of last year, pled first offender, 5 years, served 4 months, balance on probation. So you got a chunk of probation. So you're juggling a few things right now. You've got a probation situation with Judge McAfee, which you'll probably send to me so you can deal with everything in one place with one lawyer, meaning Ms. Cabrera. You've got the new charge, the gun charge with the marijuana. And you've got this new, it's a new indictment. It's an old situation. This is the fleeing and attempting to elude. And Ms. Cabrera can assist you with all of that, but she's going to want to get some paperwork on each of these things so she understands what's going on. The one thing we can't do is if you've got issues in Douglas, that's a different jurisdiction. So I can't resolve anything going on in Douglas County, but everything that's in Fulton we'll probably handle all at once. Okay? So, no, not today. Ms. Cabrera needs one. You can see she's in a car. She's on that screen right there. She's in a different jurisdiction. She's going to get all your paperwork, come see you, and then we'll figure out where we're going from there. Okay? Any other questions? Ms. Cabrera, anything else on behalf of Mr. Harris Brown?
No, I'll just have to track that stuff down and figure out what we have.
Yeah. Did you get that case number? Do you want me to repeat it?
Yeah, give me that case number again, please.
It's 23 SC 190090.
Okay, thank you.
You bet. And do you need it? His PI number is on the calendar, so you'll have that. So if you will send, when you get some downtime, a waiver of arraignment to Ms. Nelson, and I don't think you've done an entry yet. Maybe you have, but it didn't hit the calendar.
Okay.
Let me look. Yeah, so if you do an entry and a waiver, then we'll get the scheduling order out.
Okay. Yeah.
All right, Mr. Harris Brown, we'll see you soon. Thank you.
And then Mr. Gomez.
Yep. We're ready for Mr. Gomez. Unless you have someone else, I don't think you have anyone. You think they'll be here in like 2 minutes? Okay. It'd probably be better to have him at the podium if we can do that, but safety first.
Judge, Mr. Kirkandall is here. Do you mind if I go outside and go over the waiver of rights with him since he's gonna be a plea?
Great. No, please talk with him. Welcome.
Hi.
Safe travels?
Yes.
What airline?
Southwest.
All right.
Judge, I have an announcement on position 1.
Our surprise visitor, Mr. Stafford.
Yes. This is not going to resolve today. I do expect it'll resolve soon, though. I just filed the waiver and I sent the change of address to Ms. Nelson. So, and we exchanged contact information, so we're good to go.
Excellent. So, Mr. Stafford, we'll see you soon. It does sound like this is a resolvable case. You're on bond. Your bond is really old. That doesn't mean it's not a bond. And the main condition was that you were supposed to stay away from, I think it was an address in Hapeville or something. Let me pull this up. Yes. Well, Hapeville Road, address on Hapeville Road. That's it. You're not wearing an ankle monitor, are you? Good. Okay. Then Ms. Wood will let you know when your next court date is. You'll also get something in the mail. We're going to have a good address because Ms. Wood filed a change of address, and we'll take it from there. Any questions? Ms. Dilligard, anything in connection with Mr. Stafford's case?
Nothing further, Judge.
Okay. You're good to go.
Thank you, sir.
This person? Okay.
I didn't get an answer.
All right, let's bring Mr. Gomez to the door, please. He'll be there in 1 second. So what court are you going to next?
So I have 2 in Douglas County. I got to go to Judge Warren and Judge Fortner. Judge Fortner will be pretty easy. Not Judge Warren, it's Judge Wallace.
Judge Wallace.
She's at 10 o'clock though.
Okay. All right. Well, we'll wrap this up. Here's Mr. Gomez. Hello, Mr. Gomez. Good to see you. It's been a minute. Mr. Gomez, I'm Judge McBurney. You hopefully remember that. Ms. Cabrera, who you can see on the screen, hopefully, there's a screen right there. She is in Douglas County right now, but wanted to make sure she connected with your court date. She's representing you already on an older case that you and I have together. That's on a trial calendar next week. So I'm going to see you next week, and we may be resolving everything then. But it turns out that you picked up a new charge while you were in custody. That's recently indicted. It comes to me because I've got your older case. So we've got 1 judge, 1 defendant, all of his business together. And Ms. Cabrera is going to work with you on your new case as well. And it may be, although she'll need to talk with the prosecutor, that you can resolve both your cases together. But we have to have this formal conversation today about the new charges. Ms. Cabrera, are you waiving arraignment for Mr. Gomez on the new case?
Yes, waiving arraignment and entering a plea of not guilty.
Okay, so Ms. Cabrera is going to file a document that enters the plea of not guilty on your behalf. That will trigger a requirement for the prosecutor to give Ms. Cabrera the discovery, which in this case sounds like will probably be a few police reports or something, or maybe reports of deputies or detention officers. She'll share that with you. You two will talk about what we're going to do with this case. And I will see you on May 8th. More so on the older case, but if the plan was to resolve the older case on May 8th, it may be that you resolve this newer one as well, okay?
I was not saying that I haven't been able to get in contact with her. I'm working with Kendall store, but I was planning to probably next week, next Thursday, to resolve everything. I didn't want to, because I haven't been able to speak to my lawyer. It's been about, I had since October.
Okay.
So I haven't working up. I'm just saying it about because I don't know how I get a phone call.
Got it.
But I'm hoping that probably next Thursday
That's when we're gonna be together again. Your hope is to resolve everything next Thursday.
He'll
Good.
see me before next Thursday. I just need to speak to Ms. Dilgard to get her thoughts on resolution and possible resolution for both of them. If it sounds like something that makes sense, then great, we could do it on the 8th. But I'll find out ahead of that and he'll see me and know what those thoughts are before we get to the 8th.
Fantastic. So Ms. Cabrera's day today is in another county, but between today and next Thursday, she will meet with you and you two can talk exactly about what your preferences are. And Ms. Cabrera is going to give you her professional advice about, I think that's a great idea. Maybe we should try to do something else. But importantly, before she meets with you, she'll have spoken with the prosecutor so that you will know, hey, I understand you want to do X, but the prosecutor wants to do Y. So maybe we'll meet in the middle somewhere. Okay, I will see you next Thursday and we'll figure out what the plan is. All right. Good seeing you. All right. All right. So Ms. Cabrera, you owe us waiver of arraignment for Harris Brown and for Gomez, entry of appearance in Harris Brown, and you are good to go.
All right. Thank you, Judge.
Thank you.
All right. Have a good one.
All right, let's shake that off. So if we go back to our regularly scheduled calendar, Mr. Shavas, when he shows up, we'll chat. All right, Qual Davis, maybe a transfer hook. How about Reynolds Cowlin? Ms. Nelson, did you and Ms. Beskin discuss excusing position 7 or just she happened to file a waiver? I'll send her a text. All right, come back to that. Ethan Brown, he dealt with. And Mr. Kirkandall is here. So, sir, you're here for whom? Yeah. Oh, everyone's here for Mr. Roberts. You got a big fan base. All right. Mr. Roberts, you may want to reach out to Mr. Matthews to see what time he's forecasting to be here, or again, one of his associates. Today it's on just to figure out how we're moving it forward. Your case had been in the non-complex division and was getting close to a resolution point, not meaning it had been worked out, but then the prosecutor there, I guess, ran your criminal history and figured out you had enough convictions that you got bounced into Superior Court because you're what we call a repeat offender. That doesn't change your charges or anything. And obviously you still have Mr. Matthews as your lawyer, and we just need to figure out how we're going to move your case forward. But that requires Mr. Matthews or someone from his firm either hopping on the Zoom while you're here or coming in here while you're here. So I'm going to take a break. I know there's a lawyer talking to a client out there, but if you get an update about arrival time, you can let me know that, and we'll reach out to the office as well. Okay?
Yes.
All right.
Thank you, sir.
Sure. Good morning. Do you have a case on the calendar? Who are you? Oh, Mr. Shavu. Your lawyer, Ms. Cabrera, just had to sign off. She's in Douglas County, had to go into the courtroom. But she has already filed the entry of appearance. You have 2 cases, Mr. Shavu. Both of them involve allegations of entering auto, and Ethan Brown is in both of them. One of them got a few other co-defendants. I think you and I chatted before when we were trying to line up representation, but we've done that, and that's Ms. Cabrera. And you now have her contact info because I don't know if it was your grandma or your dad, she texted someone and then you said, hey, here I am. So she's got good info for you and you've got her number. I need a good address for you. Let me see what's in the system. And if the right address is in the system, then I think you're good for the day. So I got an address on Oakland Drive. Good. All right. Then you get stuff in the mail telling you when you need to come to court. Now, Ms. Cabrera, as long as you don't change your phone number, she'll be able to shoot you a text or call you when you need to come to court. She is waiving arraignment on your behalf. That just means she's entered a plea of not guilty. I'll get a scheduling order out, which will require the prosecutor to get discovery to your lawyer. So police reports, whatever they got, video. And then Ms. Cabrera will want to meet with you to talk about how does this look? This looks good for you. It looks bad for you. And you guys will figure out which way to move forward. Okay? You can. Let me add one more thing and then I will gladly take your question. It is possible that your two cases end up getting transferred to another judge. You have a co-defendant in one of your cases who is mixed up in a new big case, but he's got an older case with another judge and is going to, you have a co-defendant in one of your cases. His new case is going to this other judge because a co-defendant in that new case has an older case with that judge, but all of his cases should go to the same place, which would mean this case should go there because we try to have one judge handle all of a defendant's business, and your co-defendant would be going to this other judge. And if he goes, you go. And that may mean you're standalone. You got a case just with Mr. Brown. That may go as well. But your two cases will stay together. They may stay here, but they may go to this other judge. You'll keep Ms. Cabrera. You're not going to switch lawyers or anything. You'd be going to a different courtroom and have a different judge. But you look confused when I said that there's, what did I say that confused you?
It's in the county. It's in the institution on first case. It's like filed and filed. It's like the arts going on. So I went to court. Like the judge advised to only see after my charge. She ended up missing them because I didn't have Alfred didn't show up. The third time she was missing the first case, so I went back. And I stayed longer, and I'm like, I don't know why I'm staying, and I'm going back. And everybody, well, you came to court the first time, but that fire on, so you didn't see all your charges. So that's the case of it too. So I wanted to ask.
Oh, so you think your two indictments may be kind of connected?
I guess they don't have paperwork, they didn't have a system at the time.
Okay. But one of the cases is just you and Mr. Brown, and another case is you, Brown, Davis, and I don't know how to pronounce his last name, Cowlin. But you're saying those are actually the same thing? Okay, well, that would explain why you've got the same booking number for both cases, which doesn't make sense. So that'll be something that the prosecutor will look at. And if in fact they are the same cases, they just, with the newer one has more defendants that we learned that Davis and Cowlin are in on this as well. So we're going to charge all of them. Then they will dismiss, or the term often used is null pros, your other case, the one with just you and Brown. But let me just say up front, you can only be prosecuted one time for the same offense. And so the prosecutor can look, and if it's the same date and it says, hey, Brandon Chavou entered a Honda Accord on May 3rd, 2023. In the other indictment, it says Brandon Chavou entered a Honda Accord on May 2023. That's the same thing, and they'll just dismiss the other one. But sometimes right hand and left hand take a little while to connect. All right. You just need to stay current on both. Ms. Cabrera is now your lawyer of record. She'll keep you current. If you move or you change any contact information, make sure you let her know that. Because if she can't find you, that's a bad sign. And that's when you end up getting a bench warrant or something like that. She'll let you know if the case or cases get transferred to this other judge, because one of the guys in the indictment with more names has some new business that's going to that other judge. All right. Any other questions? Okay. Ms. Dilligard, anything you want to add for Mr. Chavou?
I have nothing.
Okay. Do you have a perspective on whether the two cases are the same case?
They look like different cases. They have different incident dates and different victims to me.
Okay.
I don't believe so, but I'll look into it further.
Okay. And it could be in the larger scheme of things, one might think, well, this was the thing I did for 3 months, but you could end up having a different indictment for each day. And then a defense attorney could say, well, we want to join them for purposes of trial, but that's, as long as the counts aren't saying on this day, this victim had his car broken into, and those are in both indictments, but it doesn't sound like that's it. Okay. Yes, sir, Mr. Chavou.
Like when I say they're the same case, I'm just saying as in altogether, I had 31 charges for the first time they split them out, but they still didn't see them all.
Yeah.
And like, when they just saw the first half, just question is, real question whether they just missing, they bring it back.
Sure. There's a great question, and it leads to lots of confusion with defendants. The judge who was dismissing things at that point, magistrate judge, is dismissing it. Were you in jail at the time? Yeah. So it's just considering, is there probable cause to hold you longer on those charges? And if an officer doesn't show up, or the officer shows up and said, oh yeah, the guy who did it was 4'2" and he had one eye, and you're the defendant, they're like, clearly that's not who did it. You're not 4'2", you've got two eyes. And so the judge can say, I don't find probable cause, and I'm dismissing the arrest warrant, basically, is what they're saying, these charges that the police brought. The district attorney can always come behind that and say, all right, we did a little more work, and that officer didn't know what he was talking about, or we got surveillance video, and there's Chavou on it. It's as clear as day. That's Brandon Chavou. And so then they can indict it, which they did. So some of your charges, I don't doubt you at all that some of the charges were thrown out. It's usually because the officer doesn't show up. But that just means for those charges, they can't hold you in jail anymore. But the DA's office can always present it to a grand jury later on. And if the grand jury said, yeah, we think that there's a basis to bring an indictment, then you start all over again. So it can feel like, wait, I thought these got dismissed. They did at that level, but they can come back in the form of an indictment. Now, if the indictment gets dismissed, that's the end of the case. Okay? All right. Any other questions? All right, you're good to go. All right, I think all we have left is Mr. Kirkandall. Do we have more on the calendar for this morning?
From this morning, no.
No.
No, Judge.
Okay.
Just Roberts and Kirkandall.
Right. But Roberts is a Keratin Matthews production. Yes, ma'am.
Thank you.
See you this afternoon?
No.
No, just like that, huh? Okay. I submitted to the consolidated trial calendar Wright and Mosley.
Yes, I saw that.
Oh, how do you already know that? That's scary. Okay. But you asked for Wright, so you're welcome. And Mosley will be at most, it sounds like, he's coming over soon for the Ferretta, would be a, can you just sit with him kind of thing?
Yes, and he's not problematic, so maybe the Ferretta will, I don't know.
Okay.
Speak some confidence.
Yeah, we'll see.
Thank you.
You bet. we still might end up trying Wright here.
Okay.
I know you want to do Gill, and I'm fine doing Gill if it depends on what I learned from that defense attorney. If he says, look, I only have one of these 2 weeks, Wright's in custody and Gill isn't. But if he is good either week, then he can go down to Emerson.
Yes, because I looked, he filed like conflicting leaves. I don't know if you saw that.
Yeah. All right, well, have a good rest of your day.
Thank you, Judge. I'm on the calendar. I'll send an email. So we have court next Tuesday, and then I have also a case in Judge Ingram's courtroom that I'm hoping, it's Caroline Tidwell. So I'll send an email, but I think it makes sense. I'm really trying to work that one out. So
Yeah, no, you may need to be there, and that's great.
Yes, and then I'll just come here afterwards.
Okay. Ms. Rios can juggle all your stuff too. She's capable.
What you guys doing?
All right, are we able to go forward? Come on up, Mr. Kirkandall. And Deputy Gordon, if you can adjust the screen, please. Now that back in action. Up a little, there he is. All right, Ms. Hicks, are you ready to go on the record?
Yes, Judge.
Great. So let's go on the record. This is 24 SC 000888, State versus Kirkandall. Mr. Kirkandall is here with his lawyer, Ms. Rios. Ms. Dilligard is representing the state. And it sounds like after lots of ups and downs and all arounds, we're in a position to resolve the case. Is that right?
Yes, sir.
Okay. Is this a negotiated plea?
Yes, sir.
All right, Mr. Kirkandall, the way this will work is that in a moment, Ms. Dilligard's going to put you under oath. Once you're under oath, she'll ask you a bunch of questions about your rights as a criminal defendant. They should be questions about topics you and Ms. Rios already discussed. But if at any point we start talking about things that confuse you or aren't making sense or just going differently than you thought, please call a timeout. You can ask me questions. If you and Ms. Rios need to step outside to speak privately, we can make that happen. But I need you to let me know that you've got a question. Will you do that?
Sure.
Good. You seem tentative.
Yeah, I wasn't sure it was gonna go this way, so.
When you say you weren't sure it was going to go this way, tell me what you mean.
You were saying there's like a back and forth between me. I was just thinking we were entering a plea.
You are entering a plea, but we have to make a record of that.
Okay.
And so Ms. Dilligard's going to ask you things like, do you want to enter a plea? Do you understand your rights? Things like that.
Okay.
And so we're just making a record of that so that if 2 months from now you say, I didn't enter a plea. Well, actually you did. Here's the record. Or if I make a mistake in our conversation and later on you think, wait, the judge did X and that wasn't correct, we're making a record of it so we can see what did I actually say. And if I made a mistake, I ought to correct it. All right, Ms. Dilligard, when you're ready.
Mr. Kirkandall, am I pronouncing that correct?
It's Kirkandall.
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 Yes.
Kirkandall. Can you please raise your right hand? Do you swear or affirm that any statements or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
And lower your hand. Please state your true and correct legal name for the record.
I'll be the Darian Marquise Kirkandall.
Mr. Kirkandall, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there any medication that you normally take that you've not taken today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 34 years old and I been to college, been to colleges before.
And do you understand that you've been charged with the following offenses: 1 count of armed robbery and 1 count of aggravated assault?
Yes.
And do you understand that you have the right to plead either guilty or not guilty to those charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove the charges against you at a jury trial?
Correct.
Have you had enough time to speak with your lawyer about the charges in this indictment, including the facts and circumstances related to the charges?
Yes.
Do you need any more time to discuss the case with your lawyer?
No.
Are you satisfied with your lawyer's services?
Yes. I mean, well, this is the best we could do, I guess.
Counsel, do you waive formal reading of the indictment for purposes of plea and waive any and all defects for purposes of the plea?
Yes.
Mr. Kirkandall, do you remember having been arrested for these charges?
Yes.
Has your attorney advised you of the minimum maximum sentence for each charge which you're pleading guilty to today? So we are reducing the armed robbery to robbery and pursuant to 16,840, the range is 1 to 20 years. And for aggravated assault, the range is also 1 to 20 years.
Okay. Yes.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, the state's recommendation is to reduce the armed robbery to robbery pursuant to OCGA 16,840 for 10 years of probation. Conditions are to have no contact with the victim, DeAndre Veal, a stay away from the incident location at 3478 Lakeside Drive Northeast, a ban from Fulton County, and for the defendant to receive both a drug and mental health evaluation and any treatment that is recommended. Judge, there's also a condition for this defendant to, within 6 months, enroll in an extensive outpatient mental health treatment. That your understanding of the recommendation?
Yes.
Do we have a definition of the word extensive?
Right.
I maybe we'll talk about that more, but I want to make sure that the conditions are clearly defined enough that Mr. Kirkandall and probation, wherever probation ends up being, don't get into a disagreement about what's extensive, what's not extensive. So I don't know
I think
where that phrase came from.
just mean that a program that's addressing his mental health needs, like once he's getting evaluated, what they deem necessary, and he's addressing those.
Okay. Right. I would assume if Mr. Kirkandall had an evaluation and medical professional said he doesn't need treatment, then he wouldn't need treatment.
I did have that evaluation.
Okay. Well, we'll get there. Similarly, if the evaluation was Mr. Kirkandall would benefit from 2 counseling sessions a week, that's scooped up by the evaluation and then follow any treatment as recommended.
Yes, Judge. I think the intent of the state, that's my understanding as a defendant, is getting some type of mental health treatment right now through BetterHelp. The state is looking for something more concrete. However, he is still in between, I think, insurances at the moment. And so that is what the state's intent.
All right, we'll flesh it out.
Okay.
We'll flesh it out. Thank you.
Okay, do you understand that that's what the state is recommending?
Yeah, but so is the current program that I'm in not sufficient?
We're not saying that yet. I need to learn more about that. And you're going to be able to tell me about the current program you're in.
That's good.
Okay. Do you understand that the court is not required to accept the state's recommended sentence?
Remember we talked about the judge doesn't have to accept it, and then we can withdraw if he doesn't. Remember?
I don't remember that. Is it? Yeah. I understand that though, what you're saying.
Okay. Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that if there are multiple charges to which you're pleading guilty to today, that the court has the right to run those sentences consecutively?
Yes.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea that you are expecting today, that you have the right to withdraw your plea of guilty?
When? By when?
Today.
Oh, today's the only day to do that?
Right.
Oh, okay. But then, yeah, I understand.
Are you currently on probation or parole anywhere?
No.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand if you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand if you fail to follow the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Okay, yes. Well, what are the special conditions?
Well, it's what we talked about, no contact with Mr. Veal, stay away from that address, et cetera, et cetera.
Even though I lived at the address?
So unless you're planning on moving back to that apartment?
No, I was planning on just going back there because I was told I have to like prosecute him after going after him after this is done, and that's what I intend to do. So I need to go back and get the actual camera footage from the manager at Analytics because they do have it. But I just had to come here because I came straight off the plane, so I had to get an attorney and then go back. I definitely,
If you get an attorney, your attorney can handle all that.
Right.
Yeah, I would definitely gonna like prosecute them. For
Okay.
sure.
And you are free to pursue all avenues in connection with this situation with the car keys and the scissors. But you would need to have some agent, whether it's the attorney or an investigator, go to the apartment complex saying, we want the footage from this unit or this camera. You wouldn't do that personally because you're agreeing as part of what you and your lawyer negotiated that you personally will stay away from
That's fine.
that unit. Okay.
Okay. So I'm just going to ask that last question again, make sure it's clear. So do
Okay.
you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
And do you understand that you're not allowed to possess or use a firearm while on probation?
Yes.
And are you a United States citizen?
Yes.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pled guilty to a felony in the state of Georgia?
No.
Have you ever pled guilty to a felony in any other jurisdiction?
No.
Have you ever been sentenced for any crime, whether felony or misdemeanor, under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status can be revoked?
Yes.
This means that you can be adjudicated guilty and you can be resentenced up to the maximum sentence for each charge in this indictment. Do you understand?
Yes.
You understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses.
Yes.
You understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial.
Yes.
Is it your decision to waive these rights, which means not to use them, and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you're in fact guilty?
No, I'm just doing the guilty under Alfred, so I don't have to go to trial.
Are you pleading guilty because you decide that it's in your best interest to do so?
Right. Yes.
And are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
I wasn't aware of that, but yes.
Mr. Kirkandall.
Yes.
How do you plead to the reduced charge of robbery and one count of aggravated assault in indictment number 24 SC 000888?
Yeah, I guess it's guilty under this Alfred. I'm guilty under Alfred.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
No.
That's what I explained about you have 4 years, like if you were under arrest.
So you didn't explain that, but it's okay. Yes, I understand.
Okay. So do you understand that for a felony charge, you only have 4 years from today to file a habeas corpus petition? Judge, if this case were to proceed to trial, the state contends that the evidence will show that on April 10th of 2022, officers responded to 3478 Lakeside Drive Northeast in response to a person shot called. The officers found the person shot on the level 2 parking deck of the Emily Lennox apartments. They identified the person shot as this defendant, Mr. Kirkandall. He had a single gunshot wound to his upper thigh. Officers applied a tourniquet and at the same time removed an 8-inch steel bladed pair of scissors from his right pocket. Officers then met with the victim, Mr. Veal, and recovered a firearm from him as well as Mercedes-Benz keys. Excuse me, sorry. They spoke with the defendant. The defendant stated that he saw the victim and his young daughter and asked the victim if he could write a story about them. According to the defendant, the victim never answered. He said that he asked if the victim could bus him to the elevator before he forgot his keys. The victim stated that he and his 3-year-old daughter were returning home from a grocery store when they met the defendant in the elevator. The victim said that the defendant told him to give the defendant his keys or he would kill him and his daughter. The victim stated that the defendant then lifted his shirt to display a large pair of scissors. These scissors matched the description that were retrieved from the defendant's person by officers during their encounter. The victim told the defendant not to do this in front of his child, and once outside the elevator, gave his keys to the defendant. He then took his daughter to his apartment, retrieved a firearm, returned to the parking deck. As the defendant approached from the stairs, the victim demanded his keys back. He stated he told the defendant to stop, but he did not. Instead, he reached into his pocket where the victim earlier saw the scissors. At that time, the victim then shot the defendant in the leg, told him to apply pressure, and yelled for help. The victim did stay on scene and met with officers when they arrived. And that is...
Excuse me. Do they know that Emily Lennox has cameras?
Hold on.
We'll have a time.
You'll have a time. I'm hearing from Ms. Dilligard, and then I promise I'll hear from you after I hear from Ms. Rios, okay?
Okay.
All right.
And that's everything for the factual basis, Judge. The victim has been notified of the resolution and is comfortable with the way that the case has been resolved,
Okay.
but did not elect to appear.
Got it. All right. Thank you. Good morning, Ms. Jackson.
Good morning, Your Honor.
How have you been?
Great. What about yourself?
I've been hanging in there. Do you have any criminal history information for Mr. Kirkandall?
Yes, Your Honor. There are 4 cycles. The last arrest was February the 23rd, 2025, out of California for possession of unlawful paraphernalia, a misdemeanor. There was no disposition for that arrest, and there are no convictions listed in the GCIC. Nothing in addition.
Thank you, ma'am. We will see you, if you are able, I think at 1:30 for the rest of our calendars.
Yes, sir.
Thanks. All right, Ms. Rios.
Yes, Your Honor. Mr. Kirkandall is 34 years old. He is coming here from California. He was living in Las Vegas for a while. I've been in communication with his mom, who is on the Zoom call.
Is that Ms. Giles?
Yes.
Okay.
And I think she did want to speak. He does have a bachelor's in communications and went to fashion design school. He currently mostly does gigs. He's an artist. He sells art. He sings. And as regards to this situation, he was shot in the incident. His side of the story is very different from what the police report indicates, that he did not show anyone scissors. He was coming from fashion design project, and that's why he had the scissors, and he didn't threaten anyone with the scissors.
Why did he get shot? You'll tell me when it's your turn. Okay.
Well, yeah, he can explain that. but he doesn't have a criminal history. I think this was a situation where because of his underlying things, it was some confusing situation for him of what was going on and how that interaction occurred. I think because maybe of his underlying mental health, there was some just misunderstanding between the two of them that ended in this situation. But he wants to resolve the case today. He doesn't want to have to come back to Georgia, and that's why he's entering the plea under Alfred.
Have you discussed with Ms. Simpson at all, and thus ultimately with Mr. Kirkandall, the whole ICOTs and how we're going to do that?
Going right after here to the supervisor and filling out all that stuff so he can get on the plane tonight to go back to California.
You spoke with Chief Woody. I don't have to call her.
No.
Okay.
I explained that it's the same situation.
Same situation. We've got a lot of those. Okay. All right. Anything else you want to add?
No, Your Honor.
Okay. Mr. Kirkandall, tell me what you want to share with me about this situation, if anything.
Oh, yeah. So, well, I had never really got a chance to actually explain my side of the story ever since I was even shot. Like the only time I actually talked to him was with I think 4 or 5 officers approached me in the emergency room when I was first brought into the actual emergency room. I was a fashion designer at the time. 2 years ago, when I lived here, I was here for a year, and I lived at the Emily Lennox building. I lived on the 20th floor. The victim lived on the 17th floor, and I had seen him multiple times, but I wasn't really interested in engaging with him, because I'm not interested. I wasn't interested in dating. So he definitely knew who I was. And so also I would just ignore him as well. I thought he had my key fob because my keys dropped and he had a big old a wagon full of groceries. And I thought I heard it fall, he had bent down and his little daughter had bent down. So I thought mine was gone, right? I had papers in my hand because I was also going to a meeting inside of the business center that same day. So I had a trifold board and I had a book, a 500-page book, and I had scissors because I was going to cut out pages of the book and put it together for my trifold board for the presentation for my meeting so I can explain my business proposal to this business partner I was looking at working. That entire day, I was also doing a photo shoot in the parking garage as well, because I did that all the time, photo shoots all around the building, because there was on the 21st floor, they have another really beautiful it's called a center for the guests. And so I did that all around. And all around the neighborhood, basically like the Emily Lennox. If you ever look it up, it's a really beautiful condominium. So when the guy says I was robbing him in the elevator, we have cameras in the elevator. That's why I never understood why they say I took his car key and then you go get your gun, you come back and shoot me on the 2nd floor. So I'm thinking, okay, well, if I really stole your stuff, why didn't you just call the police? Because I didn't have anything on me. And so when I tell you, I didn't even see him. I only seen him once, and then he told me he didn't have my the car key. I said, "Well, give me." He actually gave me my the key fob, and so it wasn't like I had to threaten him. All I had to do was ask him. And if you actually look on if there's any cameras, which there is, it wasn't a huge scuffle or anything like that. But when the guy actually came out and shot me, he shot me in the parking garage. I was nowhere near his car. I was nowhere near anything. I just walked out of the the main doors, and it's still inside of my building. So I never talked to anybody. After this, when I was inside of the hospital, he told me I was under arrest. And I was like, for what? And he said, for armed robbery. I said, robbery? He said, you tried to rob the guy for scissors. I said, with your scissors? I said, with fabric scissors? They're not like the big fabric scissors, it's not 8 inches. They were scissors from Walmart. So this is just so preposterous for me. This is preposterous to me. Then after this, the first public defender told me, this is gonna be wrapped up, thrown out. Okay, and I said, okay, fine. So I go on with my life, move in Arizona. I pursue my singing career. Then I get pulled over. I get stopped, and I actually go to jail because this is actually still going on, and I couldn't believe that. And then so after this, I'm working with Procedural, and I'm thinking, okay, I had no opportunities to even work with an actual attorney, because when you first call, when I was living in Las Vegas, the Las Vegas attorney told me it was $50,000 to actually start this case out here. Then I have to get another attorney out here for $10,000. So immediately, and then immediately I have like a $60,000 charge, and then you guys are, and then they want me to start pleading. Like I have a mental health case, because I actually went to a psychiatric hospital one time, and then I had like a diagnosis where it's like you could or could not possibly be bipolar. So I'm like, okay, well, I haven't really had a moment to really say. If you read the report, it kind of sounds kind of strange that if I'm like, okay, really going after this guy's car in the very same building that I live in, but I couldn't really tell you why he shot me, because all I could tell you was that I walked out and he shot me.
Where were you shot?
In my leg, on the second floor, inside of our same parking garage, inside of our same building.
And in the leg.
And I didn't drive. I used to take the Uber back from the airport to Buckhead all the time. All I took was Ubers. When I was here, I didn't drive, and so because I'm not from here, I'm from like Las Vegas. I'm from Northern California, like Napa Valley area, and I grew up primarily in Las Vegas. But I actually came here just for a year, just to pursue my artistry, because I was working with another artist out here, and I do that. And so,
where is home now?
Home now is in Los Angeles.
In Los Angeles.
Yes, I'm in like Hollywood area.
All right. Do you have your own place? You staying with someone else?
Yes, I'm staying with a guy, but we're like creative friends. So.
Okay.
But I literally just moved from, because I was in Arizona, because I was trying to work with Carol Fitzpatrick at ASU. So I was trying to see if like I wanted to work there, or if I wanted to actually just pursue something in Las Vegas. But I just landed in LA. I think I got a pretty good gig. So.
Do you have a job in Los Angeles?
Yeah, so I'm like an artist as well. So I was working as like a treatment coordinator for a dentistry, but so I did dentistry. That's why this is like, this is totally crazy as far as the description for me, I even to have on my record. But I'm actually pursuing like, I'm just like an actual a business deal now with a really big company. So.
Okay. Well,
so I do my thing, but I do gigs. So, any musician, any artist, they do like gigs. So I sing like gospel music, I make art, I design clothes, all that kind of stuff.
Okay. Let me see if your mother wanted to add anything. Ms. Giles, was there anything you wanted to share?
Yes, I did. I hear all what the prosecution is asking. 10 years is awful long time. You're asking also for him to do therapy. And is it a length of time for the therapy? He's doing the better help right now online, because he can't really work and go to therapy during the day or the evening. So that's why he did it. That's why he chose to do it online. I'm willing to actually pay for that, because they won't accept his insurance. So I'm hoping that this case will be resolved today. I do understand what Darian is saying. He's nervous and he's all over the place. But I don't really understand how someone can go get their gun and go back and shoot him. I don't understand that. I'm sure that something happened between him and the young man. But to go get your gun and now meet him and open the door and shoot him, he should have called the police.
So, I hear you, Ms. Giles. There are a lot of shouldas in this situation that probably would have resulted in no one getting hurt. What the state has alleged, and right now we don't have Mr. Veal here, and we're not doing the trial, and mostly I'm hearing from your son, Mr. Kirkandall, and I appreciate getting his perspective. But what Ms. Dilligard said on behalf of the state is that what she believes the evidence would show is that Mr. Veal, armed, did come back to find your son to say, you need to give me my keys back. In other words, Mr. Kirkandall had taken something using threats from Mr. Veal, and Mr. Veal was trying to get that back. Right or wrong, he showed up armed. Currently, he's not in the wrong yet. He's simply saying, I want my keys back. And it sounds like what he would testify to, and I don't know what the cameras would show because we don't have that footage.
Right, exactly.
But of course, if the camera showed what Mr. Veal said, a jury would see Mr. Kirkandall menacing with the scissors, and then the state's theory would be Mr. Veal is defending himself, and that's why he fired one shot. You don't need to respond. You may be unpersuaded by that. You may be unpersuaded by that. And I respect that. But what you're saying today.
Your regular bowl. Eat that food.
Let's get rid of that person. I don't know who that is. But what we've got, Mr. Kirkandall, is someone saying, I don't agree with the state's version of events. That's what an Alfred plea is. That's not how it went down. But it's in my best interest, meaning your best interest, to resolve this case this way, rather than having to come back here, having a trial, having Veal come in here and testify. And this is the important part. The state, if you go to trial, is not reducing armed robbery to robbery. And if you were, I don't know what would happen at trial, but if you were found guilty of armed robbery, that's a mandatory minimum 10 years in prison, no possibility of parole. So that's a number, even though it's the same 10, that's a lot bigger 10 than 10 years on probation, because you're in prison for 10 years, no parole. That's what happens if trial goes poorly for you. Trial might go phenomenally for you, but I respect your decision after getting the advice both from your mother and your lawyer to say, I don't want to roll those dice.
No, I'm just saying, I can't believe all this is happening. Like, this is just, it's insane, but okay.
So
it's happening. It is happening, son.
This is crazy.
So I will say it is happening. Something happened between the two of you. You got a good deal. My suggestion to you is to roll with it.
Okay, Mom, let's go.
That's my suggestion to you.
Thank you, Ms. Giles. One, I appreciate you connecting here. It's important for me to see that Mr. Kirkandall has family support. That's always good. And two, your perspective is a valuable one. Where are you calling from? Are you in California or Nevada or Georgia?
No, I'm in Las Vegas.
In Las Vegas.
I wasn't able to attend the appearance this morning because I actually just recently had surgery.
Okay. Well, I hope you're recovering.
Be online.
Okay. Well, I hope you're recovering nicely, and you're here. Virtually, you're here. We can see you and hear you, and I appreciate that.
Thank you.
All right. Thank you. All right. Take care.
One more thing, Your Honor. I was going to ask for a behavioral incentive date of 3 years.
Okay. All right. Mr. Kirkandall, I find that there is a factual basis for your plea. And what that means is that if the state's version of events is what the jury heard, a jury could find you guilty. I'm acknowledging that they're competing versions of events. You shared with me your recollection of what happened. Ms. Dilligard, who wasn't there, is sharing what was told to the police by Mr. Veal and the work that they did. And if a jury believed that version of events, a jury could find you guilty of armed robbery.
That's why I thought it was so important to get the Amtley lineage footage, because they have it. But now you're saying I can't even go to the my old apartment building that I was a resident in. Like I actually was on. I had my own condo there. And you said I can't go back there.
Right.
I can't even come back to Georgia. So I can't even go back and actually adjudicate myself. Not that I even want to come back to Georgia, but I'm just saying, like, I can't even like come back to Georgia to even try to get this like rectified, because I actually was shot from somebody. But it's totally fine.
No one's doubting you were shot. That's a known fact. But what we discussed is someone can get that footage on your behalf. You personally can't go there.
Well, for like $60,000 they can.
Well, that's one approach, is a $60,000 approach. You may have a friend who could go do that. You aren't going back to the condo building.
Yeah. I mean, no, I don't even live here.
It's better for everyone. If Mr. Veal's still there, you don't want to bump into Mr. Veal. Not good for you, not good for him. It didn't go well. You know that better than anyone. So you can understand why the state would be requesting, let's just keep everyone apart. And you being in California is about as far apart as it can be.
I know, far from Georgia.
Yep. So I find there's a factual basis for your plea. I also find that your plea is what we call knowing and voluntary. Voluntary, you know what those words mean, but I got to make a record of it. Voluntary means that no one's forced you to enter this plea, that as you've thought about the risks of going to trial, the benefits of this option, you've concluded that an offered plea is the right way forward. A knowing plea means that you've understood what we talked about. And if you didn't, you did what I asked you to do, which is say, wait a minute, explain that. Or you talked to Ms. Rios. And so I do find that you've understood what we discussed. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, if you have a minor violation, maybe you miss a meeting or something like that, then you and probation work through that. It's only the more significant violations. If you get arrested again, that comes back to me and I will work through the consequences of a new arrest.
Okay.
Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
Ms. Dilligard, can we sign for you?
Yes, Judge.
Mr. Kirkandall, we now use electronic signatures for many things. Can we electronically affix your name to the indictment indicating your offered plea?
If that works fine.
Great, thank you. I will follow the negotiated resolution in this case. On count one, which the state has decided to reduce to robbery, your sentence is 10 years. Count two will also be 10 years. They'll run concurrently with each other, meaning at the same time. I'll probate those. Special condition of probation number one is no contact with Mr. Veal. You don't text him, you don't write him, you certainly don't go knock on his door. Number two will be that you stay away from the condominium complex at 3478 Lakeside Drive.
What if he contacts me?
You should let Ms. Rios know that, because it's not meant to, this condition is not a trap. But you don't write back. What you would do is say, look at this. I got a letter, I got a text. Like, what the heck is this?
Okay.
And then Ms. Rios can let Ms. Dilligard know. And Ms. Dilligard, who knows how to contact Mr. Veal, can say, what are you doing? It's a stay away. You need to leave him alone. He isn't bothering you. You need to not reach out to him.
Okay.
Okay. Now, the exception to that would be, should you pursue a lawsuit against him, your attorney or a representative of that attorney could seek to contact Mr. Veal. But you don't directly.
Right.
And you don't have a friend do it. It's not my friend, the fake lawyer. It would really be, this is my lawyer, should you decide you're going to do something about it. Okay? To make it easier to stay away from the Lakeside Drive location, I'm going to add as a condition of probation that you stay out of Fulton County.
Okay.
That doesn't mean you can't fly through Hartsfield. Hartsfield is not in Fulton County. So if you are traveling around because of work or leisure or whatnot, it's okay to fly to Atlanta as a stopover, but you just don't come into Fulton County. But that airport is not in Fulton County.
Oh, okay. Yeah, no biggie.
Okay. You will need to, within the first 3 months of your probation, submit to a drug and alcohol abuse evaluation, and then follow any treatment if that treatment is recommended. Similarly, you're going to need to submit to a mental health evaluation. You mentioned that in the past there had been a possible diagnosis of bipolar and who knows what's out there, but a medical professional will spend some time with you, and he or she at the end of the evaluation may recommend treatment. And if there is treatment recommended, you need to follow that treatment as part of your probation.
Okay.
Okay, whatever that treatment is.
And that's out of California.
That's where it will be, because you'll have had your supervision transferred to California by then. So it won't be back here. You don't need to come back here.
Okay.
Okay. I will set a behavioral incentive date of April 30th of 2029. That's 4 years from now. If over the course of the 4 years there haven't been any major hiccups while you're on probation, then probation can turn to me to say, look, Kirkandall is stable, got a job, no contact with Veal, taking mental health meds or whatever's going on, then I can think about saying, well, let's cut this short, because what's the point of year 5, 6, 7, 8 if you are in a safe and stable place? If you're not, because you're having struggles, You know, the most it would be 10 years of probation.
Okay.
You are asking to be sentenced as a first offender, to which you are entitled. That's primarily a benefit. That means that this is not a conviction, but it carries with it a pretty big risk. And that is, if you get in trouble for something else while you are on first offender probation, not only would you have those new charges in California or Nevada or wherever, but you will come back here and we would have a hearing, and the state might ask me to take away your first offender status. You've already pled guilty to robbery and aggravated assault, so you don't get a new trial. You would have a hearing, and if I found that you, Mr. Kirkandall, 6 months from now, committed this new crime, I could resentence you on this case, not as a first offender, but as someone who pled guilty to robbery and aggravated assault, and I could sentence you up to 40 years. Now, I'm not saying you get 40 years, but what I am saying is if we're back together again in 6 months, 9 months, and you threaten someone out in California, and the state proves it up here in that hearing, I will be revoking some of that because you will have not found that safe and stable situation in your life. And you will be a risk to yourself or maybe a risk to others. And that's not okay. I want you to be safe. I want just as much that people who come into contact with you to be safe as well. And so if something is happening in your life where law enforcement gets involved and it indicates to me that you're not enjoying that safety and stability, then I would be in a position to say, no more first offender, resentencing you in, I'm making it up, 3 years in prison or something. And that's not the new thing, that's on this old thing. So first offender has that risk. The benefit is it's not a conviction. If you're trying to go back to school, looking for a job, you can, with a straight face and a clear conscience, say, I'm not a convicted felon, because you're not convicted of anything. Yeah. That's the good side. The downside is if you get mixed up in something while you're under this sentence, it can all come tumbling down pretty hard.
Well, that was the benefit of it as well. It was like the school aspect of it, because I wanted to go to school for astrophysics, science, and physics. So within the next 5 years. So that's why when she did explain to me the benefits of the Alfred, right? First offender. First offender. That's what I thought was the biggest benefit, was that I was going to be able to like not have this felony on my record, so that I could still attend school and certain condos and apartment complexes.
All that stuff. You can do all that, but it just has that risk. Do you feel like you understand the benefit and risk of first offender?
Yes, but I don't plan on getting in trouble at all.
Okay, yeah. Excellent. That's a good plan. Then I will sentence you as a first offender. And I think I've covered everything. Did you have anything else, Ms. Dilligard?
No, Judge, nothing further from the state.
Okay. Ms. Rios, anything else?
No, Your Honor.
All right, Ms. Simpson, what do we need to do for Mr. Kirkandall to get this ICOT's process rolling?
I need his address and a contact number. And of course, Chief, what he needs, the signed disposition from you. Ms. Rios already gave me the incident report.
Good move. Okay. We'll get that signed disposition. Just send it to you and you'll take it from there. Okay. Mr. Kirkandall, we're going to go off the record now. You and Ms. Simpson can talk off the record about your address, contact information, et cetera. Okay. Your next stop needs to be the probation office, which is like 2 blocks from here. You'll get directions. Okay. But you'll want to cruise on down there so you can start getting processed out for your supervision to be transferred to California.
Okay.
Do you have questions about anything we've discussed?
What if they can't do it today?
It's going to get done today, though. I don't see it.
The starting process of it will be done today.
Yeah, the part where you need to be here in person will be taken care of today. The pieces of paper that they need, they'll be getting. The police report from 2 years ago, 3 years ago, your sentencing document, I got to go finish that. We'll send that there. They just need you.
I was gonna say, and when does that need to be actually
you need to have there as soon as you finish.
Right. Okay. And then you said if you said it's starting today, so
right, the transfer process, we have to fill out some paper in Georgia, and then Georgia reaches out to California to say, here's Mr. Kirkandall's case. Would you agree to supervise it? And there's an understanding in general that because there's an agreement between the states, if Georgia asks California, would you supervise this? California says, sure, because if someone is arrested in San Francisco who's from Atlanta and wants to have his probation supervised in Georgia, when California says, hey, would you supervise this? Then Georgia says, sure, we'll do that. So it's a reciprocal understanding. It just, as you can imagine, it takes a little while for a Georgia entity and a California entity to talk and work through all that. You do not need to wait here for all that to happen. You need to be here today to get it started.
Got it. And then if they deny, could I do it in another state, like Nevada? Because I'm just thinking, I just don't.
Cross that bridge when it happens.
Right.
It's going to get denied. So
I just want to make sure I get everything, because I'm only here for today.
Right.
So I want to get as much information as I possibly can.
So
that's all. Okay.
yeah, ask them that question and say, hey, what would happen if California said no?
Right.
And they may have an answer, or they may say exactly what Ms. Rios said, which is,
I don't know how that works.
yep, I don't know how that works either. I've never heard of it being denied, which is a good sign.
All right.
All right. That's it. Thank you, everyone.
Thank you so much. I really appreciate it. Thank you.
You bet.
you can talk to Mr.
Okay, thank you.
Hi.
All right. Mr. Matthews is on the call, the lawyer. Is Mr. Roberts out there? Remember the guy who had a bunch of people here?
Good morning, Your Honor.
Good morning, Mr. Matthews. Thank you for joining us.
No, thank you for waiting for me to get on board with you guys this morning. I had several court appearances this morning in other circuits.
No, we got notice of that, and we're just trying to, I think your client went outside, and we're just trying to get him back into the courtroom so we can make a plan.
Okay, thank you.
Mr. Roberts, why don't you come on up to the podium, please? Let me remove this. All right, can you slide that way a little bit? There we go. And let's get Mr. Matthews on the screen. There he is. Okay, we need to talk about your case. Mr. Roberts, as I mentioned to you this morning, just to explain why you're suddenly in front of me, your case was transferred from non-complex randomly to one of the judges. I got it, just because of your criminal history. And we need to figure out the way we're going to move this forward. Mr. Matthews, you had filed in the non-complex division, I think, a motion to suppress and a couple other things. And I'm fine just sort of picking up where things left off. I don't know if you want to talk with Ms. Dilligard, who is the prosecutor now handling the case, about what's next. But I want us to leave today with an idea of when we're reconvening and what we'll be doing when we reconvene. So why don't I start with you, Mr. Matthews, and we'll then hear from the prosecutor.
Okay. So again, Your Honor, thank you. The case was transferred to was moved out of non-complex on March 14th of 2025 by Judge Brandy Brooks. It was e-filed into the clerk's office on March 18th, 2025. I did file a battery of motions into the case in the non-complex division. I was going through my channels to determine whether or not I received the discovery before the transfer. I do not show that the discovery was sent pre-transfer. So I like to get the discovery, and then I'll particularize any motions that I believe are appropriate and notify the court as well as the prosecutor of those motions so that we can discuss the case with the prosecutor as well as potentially have a hearing if necessary.
Got it. Okay. It doesn't look like we need to do arraignment again because in July of last year, there was a waiver filed. So why don't I have Ms. Nelson enter a scheduling order that will give the state a pretty quick turnaround time to get you discovery. And then that'll give you a deadline to file any motions. And what I would ask, just because my motions practice is a little different than non-complex, is if you review the discovery and conclude, you know what, we don't need a Jackson Deno, or we don't have a motion to suppress, that you would file something withdrawing what you filed before. Because right now, when I look at the docket, I think, we need to set this case down for a motions hearing. But it sounds like out of an abundance of caution, to protect your client's rights, you filed those placeholders, not really knowing what's in the discovery because you didn't have it yet. So we'll get you that discovery, and then by the motions deadline, either you would particularize motions, or if there's actually nothing you need to move forward in that way, you'd file something, Mr. Matthews, that says we're withdrawing our pretrial motions, and then we'll just move the case to a final plea calendar.
Agreed.
Okay. Mr. Roberts, do you have any questions about anything we talked about?
No, sir.
Okay. Ms. Dilligard, anything from the state?
I'm checking, it looks like discovery was served in October, but I'm gonna send a note right now to have that sent over to council, so I'll send that request.
Okay, thank you. And that'll be an evidence.com link or whatever the form is? Okay, I mean, it's older stuff that Mr. Roberts was arrested back in 2022 for this, so hopefully it's still in the cloud somewhere or wherever that is kept. Mr. Roberts, someone from your family reached out to my staff, I think it was yesterday, to talk substantively about the case. You may want to talk to your family members to encourage them not to do that. It doesn't bother my staff, but really they should be talking to your lawyer, Mr. Matthews, rather than folks on my staff about who is going to take the fall for your charges and that kind of stuff. Right. A little peculiar, but I just want to let you know that had happened. And that kind of communication should go through Mr. Matthews, and he'll know how to funnel that. Okay.
Yeah, I had no idea.
That's all right. I'm not fussing. I'm just letting you know someone called to say, you know, the son's going to take the fall for the father, that kind of thing. Like, we don't need to know that. That may be a defense that Mr. Matthews wants to bring, but family doesn't need to reach out to talk about that. So, and if someone does, I need to let the lawyers know on both sides. And that's problematic if someone were to call to say, well, Mr. Roberts only had the cocaine, not the gun. I need to tell the prosecutor that this person says that you had the cocaine but not the gun, and Mr. Matthews might be frustrated by something like that. So run it through your lawyer, and have your family run it through your lawyer, and he will manage it from there. Okay?
Yes, sir.
I want to put on the record, I received a similar call yesterday afternoon as well.
All right.
Can I inquire, Your Honor? Can I inquire with Madam Prosecutor? Was she able to ascertain a name or anything of that nature?
No name, wanted to remain anonymous, but I do have a contact phone number that I can share with you.
Okay, that'd be great. Would you be willing to put the substance of that call on the record?
It's very similar to what Judge notated, that she was made aware that there was going to be a statement that the son was going to come in and take ownership of the drugs, and that wasn't true.
Okay, thank you.
All right, the plot thickens. You all need to stay focused on discovery. We'll get to Mr. Matthews. Then you, Mr. Roberts, and Mr. Matthews will look at the discovery, decide if there are motions that we ought to talk about. And if not, this is an old case. I want to get closure, whatever closure means. Dismissal, trial, a plea, whatever that might be. But I'm sure you're anxious to move along as well. So we will make that happen. Let me check one thing, just given the age of the case. Bond. So you got your bond 3 years ago almost. But it's still your bond. It's a little bond. Just says you're not supposed to have guns or drugs without a prescription. I want to make sure you didn't have an ankle monitor or something that was unduly restricting your ability to go about your business, just given the age of it. But it's a pretty standard bond.
Yes, sir.
All right. Mr. Matthews, anything else on behalf of Mr. Roberts?
Not for the defense, Your Honor.
All right, we'll get a scheduling order in place. You'll get discovery, and you'll get a motions deadline.
Awesome. Thank you. Can my client and I be excused? Mr.
Oh.
Robert and I?
Yep, both of you may. We'll see you guys soon.
All right, thank you.
Bye-bye.
Sure.
All right, so we will be back at 1:30 for some probation revocation action. We have one where it is a petition from the DA's office.
Yeah, or petition.
A lot of this stuff is old, not just that petition. We got some warrants that were signed.
Who's handling the juvenile case? Because I'm assuming it's not me. I think my understanding.
I'll tell you, Ms. Wood bolted, so it's you.
Because we're not even supervising him, so.
Who is that?
My understanding is that it's Miss Singletary.
I don't, oh, is that the one where it's the DA's office did it?
Yeah, Cameron Wright, position 3.
Cameron Wright. Is that person still a juvenile?
Yeah.
I don't even know.
My gosh, how old was he when this happened? He must have been like 10.
I was wondering the same thing because, he's not even 16 yet.
Wow. Does Miss Trotty still work in your office?
It's not. Oh, wait, actually she does.
Okay. But you'll handle it for the state?
Yeah.
Okay, and we just need to know who's handling it for.
Because, I emailed, Angela, she said it was a conflict back then, so it should be the conflicts office maybe? I don't know. I don't know what happens when they're juveniles.
Me neither. That would explain why it's not a petition like I normally see. Okay, interesting. Well, I look forward to it. And then the final plea that we've got, this lawyer has a bunch of conflicts, so it may be sort of like with Mr. Matthews. We'll catch him when we catch him.
You have a final plea today? Just one.
One position and not yours. No, Juan Edwards is on for 2 revocations.
It's the only bench warrant for the morning, Mr. Hill.
Oh, good question. Yes. Yeah, Ms. Nelson let me know that position 7 had been excused. So it's just Mr. Hill. That's it. Ms. Hicks, we are gonna be in recess until 1:30. So you should go about whatever business you want. And if you can just pop back on at 1:30, we will benefit from your services then.
Will do, thank you.
Thank you. Mute the podium.
gradually turns partly cloudy across North Georgia. Now, a lot of clouds, but no rain to track. Live storm tracker 2. HD radar showing it dry. For now, we're at 73 in Atlanta, some more sun. In Eatonton, we're at 77, a little less sun. In Gainesville, at 70 and low 70s now in Blairsville. Setting up the rain forecast for the next few days. Just a couple of showers around for today, tomorrow, and into Thursday. The rain chances are isolated. Saturday, and then we're going to clear out time for the second half of the weekend, especially. Sunday is going to be a beautiful day. But through the rest of the day today, here's our forecast by 5 o'clock. Couple of pop-up showers develop. Won't be a whole lot of rainbow today. Partly cloudy sky. We're up at about 80 degrees for a high today. We start out with some fog tomorrow morning, and then into the afternoon, farther to the north. So into Metro Atlanta, a better chance for an isolated shower or thunderstorm tomorrow. Also Thursday as well. Here's your 5-day forecast. Weekend always in view. We're at 80 today, low 80s on Wednesday and Thursday. Friday as well. Rain chance to be doubling though on Friday, up to 60%. Some showers and storms at least through early afternoon Saturday. Drier by Sunday. Here I'll just update your full forecast. Thank you very much, Brian. Reporters in John Chris again. Continues 4 o'clock.
Good morning, Bob. Convenient charging your phone in public could put you at risk. Channel 2 consumer advisor Clark Howard has been
All right, we should be back on with audio. Let's make sure. Ms. Hicks, are you able to hear us?
Yes.
Great, thanks for rejoining us. So we have two calendars this afternoon. We have a single position final plea calendar, Jonathan Darcy. You're Mr. Darcy?
Attorney William, Mr. Darcy.
Attorney William, you work with Mr. Howard? Fantastic. All right, well, we'll do that first in just a moment. And then we have a probation revocation calendar. I'm just going to figure out who has which case. And if we know if it's going to be a negotiated, admitted to revocation or not, we can maybe announce that. So the first position is Bernard O'Neill. He's in custody. Who's handling that for Mr. O'Neill? Expired. Gosh, is there anything else holding Mr. O'Neill?
No.
No. How long ago did it expire? I'll represent him. I'm suing the county. What? Hopefully it expired like 30 seconds ago. Maybe we shouldn't say out loud. Maybe you could like do hand signals for how long ago it expired. Okay, that's an easy one to handle. We'll bring him out and I'll explain the situation. But he's got a booking number was he picked up on?
He has something, I think he actually might have a parole hold.
Oh, all right, so before you get an attitude about it, he has other things keeping him in. All right, let's look.
That case expired January 1st, 2022.
All right, let's not say the year anymore. All right. All right, thank you. Let's hope he wasn't arrested on that warrant. Yikes. Cruelty to children in the 3rd degree and battery. He's got bonds for that. And then there's a parole violation. That's what, hopefully that's different from this.
It's for the parole was for misdemeanor charges.
Okay. Parole?
Yes.
Really? Okay. Is it a Fulton case? Well, we'll close out our part. We know we can do that.
It's for a misdemeanor battery and a felony.
Okay. All right. We'll figure it out. Thank you. How about, it's another old case. Ms. Carlin?
Afternoon, Judge Kevin Ryan, Ms. Carlin, she's here. We've got an agreement and we'll stipulate.
Great. Thank you for being here, Ms. And which one of you is Ms. Carlin? Oh, she's in custody. Okay, that's what I thought she would be. So she is here. And you and Ms. Dilgard have already spoken.
Yes.
Okay, great. We will turn to that after we do our final plea. Cameron Wright.
Yes, Your Honor.
Oh, right. This is right with just an R. This is the one where we've got the petition from the DA's office as opposed to a warrant, because Mr. Wright is still a juvenile. This is not a new case, and he must have been 12.
I believe he was 13.
Okay.
By the time the case was resolved, he was 14.
Yeah.
And he's been under my supervision since that time.
Okay. Ms. Nelson told me the bad news that for whatever reason, people can't go forward today.
Yes, Your Honor.
Is he in custody?
No, they were parking about 10 minutes ago.
So he'll be here?
Yes.
Okay.
You want to wait for him? Or?
Yeah, let's just wait for him. I'll be anxious to understand why we can't handle it today, since this was filed like 20 months ago. But I'm sure you'll have a good explanation for him. And it's new space for me, so you can make it up and I'll have to believe it. So, all right. And then how about Juan Edwards, our last two positions?
We are ready to go forward with the revocation hearing.
Okay, and you're handling both cases. All right, thank you. Then let's start with Mr. Darcy. Mr. Darcy, if you'll come on up to the podium, please. Mr. Pulliam, if you'll join in. All right, Mr. Darcy, I'm Judge McBurney. Your case is on for final plea. That is a time when I hear from the prosecution what their current recommendation is in the case. We get that on the record. We'll get on the record in just a moment. And then you either directly or through Mr. Pulliam let me know, yep, that's what we're doing today, or I understand what the state's offer is. I say no, thank you, and I want my case to go to trial, and you are on our June trial calendar. So let's get on the record first. Ms. Hicks, you good to go?
Yes, Judge.
Thank you. All right, this is case 24 SC 005-330, State versus Darcy. Mr. Darcy is here in court with one of his lawyers, Mr. Pulliam, who is a colleague of Mr. Howard's, and Mr. Howard let us know he'd have a conflict. So Mr. Pulliam, I appreciate you being here. Mr. Darcy, you're charged with aggravated battery and family violence battery. Mr. Pulliam, from your review of the file, do you feel like you have all the discovery in the case?
That's a great point, Your Honor. So we just received discovery a couple of weeks ago. I will say that there's a motion that either should be filed by my admin or will be filed later today that we would like to be heard on. It's an immunity motion for this particular case.
Okay.
It looks like it was on for motions hearing in March. We didn't yet have discovery in that case. Discovery was served a couple weeks later in April, a couple weeks ago. We've had the chance to review that because that immunity motion, if not filed, should be filed by later today. And so we will ask for that to be heard. I do think that if we're successful in that motion, that this case will be resolved at that particular point.
Well, it sure would if you're successful with that motion. The case goes away. Damari Kawasaki, is whom to you, Mr. Darcy?
It's his brother-in-law.
Brother-in-law, okay. And Dustin Kawasaki?
My husband.
Got it, okay. And are you and Dustin still married?
Yeah.
Okay.
We just got married.
Then I'm assuming the bond doesn't say you can have no contact with Dustin, or it would have been a funny marriage.
Yeah.
A virtual one. You need to have no contact with Damari. Okay.
That's correct.
So I guess Damari didn't come to the wedding.
No.
Okay. Yeah, no violent contact with Dustin. Okay, got it. And he, in fact, asked to be able to have contact with you at your bond hearing a long time ago. Okay, I just wanted to get oriented on that. Ms. Dilligard, what's going on with discovery?
So it looks like discovery is counsel was accurate. Discovery was served on April 8th. So
Maybe I should ask differently. Why would discovery have?
been that.
Yeah.
Judge, I am not sure I have an answer for that at the moment. I will look into the matter though, to see what happened with discovery and its tardiness.
Okay. Mr. Pulliam, you and or Mr. Howard have had enough time to look at discovery to believe there's just one motion that you're going to be filing, or do you also have a request of, gosh, we need more time because we did just, I guess you've now had discovery for 21 days. So you've had it for enough time to know what motions you're going to file. And it sounds like the immunity motion is the motion.
That's correct, Your Honor.
Okay.
So that's my review, so.
So then what we ought to do is not do the final plea hearing. We ought to have the immunity hearing. If that goes well for Mr. Darcy, case goes away. If it doesn't go well, case is still here. And what I'll probably do is just move it straight to the trial calendar. In fact, if there's a way we can pull it off, don't know that we can, get that immunity hearing in before the trial calendar, then either the case is dismissed or the call of the trial calendar would be the final plea hearing in this case. If the immunity motion is denied, then the charges still stand. And then we'd have the conversation I thought we were going to have where the state would say our recommendation is X and Mr. Darcy can say, no, thank you, I want to go to trial, or yep, this is my best chance, so let's do it now when I can still withdraw my plea if I end up getting a sentence I don't like.
Yes, Your Honor.
Okay, so I'll preserve the final plea process until at the earliest, the call of the trial calendar. It may have to be later than that if we can't fit the immunity motion in.
Okay.
How many witnesses do you think you'll call and how long do you think that'll take?
2, maybe 1 or 2 hours. That would take,
Okay.
So.
So we ought to be able to handle the immunity motion in a half day.
Yeah, most definitely, Your Honor.
Okay, all right. Ms. Dilligard, anything else from the state in Mr. Darcy's case?
Not at this time, Judge.
Okay. Then that's it. Continue to stay away from one of the Kawasaki's, but not the other. All right?
And we just be giving notice about the next court date.
No, you're just gonna have to guess when it's gonna be. Yes, we will send out notice. Like I said, we'll see if we can find a half day, and I don't want anyone to be surprised. We have a senior judge who helps with immunity motions just because they take a big chunk of time. And I may refer it to him here. You'll be coming here, not this courtroom, but you'll be coming to this courthouse for the immunity hearing. I don't control that. If that's the route we take, this will have to come off the trial calendar because I don't know when Judge Dempsey is the judge, when he'd be calendaring the immunity motion.
Yes, Your Honor.
So that's where we are.
Okay.
All right. Do you have any questions, Mr. Darcy?
No.
No? Okay, that's it?
All right, thank you. Well, that concludes our business, Your Honor. May we be excused?
Yep.
Thank you. Thank you.
Are you Mr. Wright? Which one is Mr. Wright? Okay, sorry, Cameron Wright. Which one's Cameron Wright? There he is. All right, thank you. You're all Mr. Wright. Thank you for being here. All right, my thought is we figure out what we're doing with Mr. Wright so they don't need to stick around since it sounds like we're not doing something. Then we handle Ms. Carlin's situation because we've got a bunch of folks here. And then Ms. Rios will turn to your cases. You all right with that? Okay, all right. So I think Mr. Wright can stay right there for now unless you want him where you are, Ms. Singleton, but I'm happy to hear from you what's going on. I know this isn't your petition. I guess it sort of becomes Ms. Dilligard's, although Ms. Trotty, I think, had a special role in the DA's office where she was handling those cases that kind of straddled juvenile court. And was this one of the cases where like we took a plea here, but the disposition was in juvenile court? Or am I misremembering?
No, Your Honor, this was one of the cases that was with the SB 440 unit
Mhm.
during that time period that the DA's office had it.
Yeah.
Ms. Trotty was one of the DAs that was over the unit. She is actually on Zoom.
Oh.
The immediate situation as to why he would not be able to go forward is that unfortunately it did not cross my mind until closer to this court date that his attorney situation. So he had the conflict, he actually had it wasn't Ted Johnson. He had a C3 or conflict attorney at that time. The co-defendant had the public defender. So I had to reach out to the conflict defender's office to find out what we needed to do since it would be technically considered a closed case because of the sentence. And I was informed that the PD's office would need to resubmit the conflict, which they did this morning.
He had Eric Johnson at the time.
Yes.
So we'll need a different lawyer. Sometimes the public defender's office covers revocations that were originally where the underlying the plea or the plea usually was handled by the conflict defender's office. That's not happening here.
No, Your Honor, that's not going to happen here. So they did submit the paperwork this morning for the conflict defender, which would be likely Mr. Kraft, Alfonso Kraft, with the SB 440.
Sure.
And so we're just waiting for that paperwork to go through. Usually takes no more than 2 days, no more than 48 hours, sometimes less than that. So my thoughts about that were that if possible, it would be reset to one of the calendars next week. I know I have a couple of calendars in here, or whatever's available for the court.
Sure. And we're always happy to try to wedge things in. If you're going to be here, we should do that. Mr. Kraft would need to be able to get up to speed. It sounds like, unless something has changed in the petition, that there's an allegation that Cameron Wright picked up new charges, but it was about 2 years ago.
He did pick up new charges that were juvenile court charges. Those cases have been resolved, and they have been sealed, but I do have the documents for that, and Ms. Trotty is aware of the facts of that, which led to her filing the petition. There would be other things that we would need to discuss at a revocation as well. There are a couple of conditions on his original sentence that he cannot satisfy because those programs do not exist.
Oh.
So depending on what would happen at the revocation, I would like to modify that, as well as he is not compliant with some other of the conditions that were listed. So.
Okay, so like there's no more LEADS program or juvenile initiative program?
Yeah.
Okay.
And those went away fairly early on.
Okay.
So if, again, depending on how the revocation would end, I do have other programs that he could be put in if that is something that needed to happen. I have spoken with him about those. The must enroll and remain in school. The court had asked that he graduate from high school based on the fact that we had information that he was academically strong. However, he has not been able to maintain school. And
Okay.
so I would be requesting.
Got it. I see that. And so we'd modify that as well. Okay. Well, we'll need to get Mr. Kraft in the mix, and hopefully his schedule supports a window next week where he could be here when you're going to be here.
He's on one of the cases next week.
Oh,
Yeah.
well, great. But it's really not my office that should do the outreach. It's the public defender's office has filed the conflict notice, and hopefully that gets routed to him promptly.
Yes, Your Honor, and for the SB 440s, I'm pretty involved in that, so I've already followed up with the PD that needed to do the paperwork. Paperwork's already been completed and signed off. It's transitioning over to the conflict defender. I've already provided Mr. Kraft with all the documents.
Oh, so he's not going to be surprised when he gets Mr. Wright's file. Excellent. Thank you for doing that. And Ms. Dilligard, this is something the state's still pursuing.
Yes, Judge.
Okay. All right. Then we'll see if we can find a date next week. So, Mr. Wright Senior, you're the one probably who would need to get Cameron back. Are you the one who got Cameron here? Okay. He may need to come back to court next week because he is entitled to a lawyer, ought to have a lawyer, but that lawyer hasn't technically been assigned to the case yet. That'll happen today or tomorrow, and then that lawyer may want to reach out and speak with Cameron before everyone comes to court. But at a minimum, he'd talk to him when we come back to court. Ms. Singleton, would you be notifying the Wright household of next week's date? Because we wouldn't be able to get U.S. mail notice out in time, probably. If I'm making it up, if we added it to the Tuesday calendar of next week, I don't know that the clerk's office would generate that and get it through USPS to the Wrights.
Yes, Your Honor, I'll notify.
Okay, all right. Will that pose a difficulty on your household to get Cameron Wright back here next week?
One question. Can he get a G, because he don't, I guess he don't qualify for the high school, so if he can get a G.
Yep, that's one of the things Ms. Singleton just mentioned, that way back when, in September of 2022, when we were doing the sentencing, one of the conditions was that Cameron has to graduate from high school. And Ms. Singleton was helping me understand that that's not realistic. And so she was going to suggest that we substitute GED for graduating from high school. I think that makes a ton of sense. We're not doing that today. We'll do that next week. We'll probably need to change a couple things in the sentence so that it is more aligned with what is realistic for Cameron to do over the next couple of years. Okay? But we'll talk about that when Mr. Kraft, that's the name of the lawyer who will be working with Cameron Wright. When he's here, we'll talk about that. Okay, any other questions? Okay. Cameron, do you have any questions?
No, sir.
All right, you've been staying out of trouble? How much have you been staying out of trouble? A lot or a little? A lot. All right. And who do you have here with you?
My little brother.
Hey, little brother, what's your name? Jaquavius. All right. Well, I will see at a minimum Cameron back here next week. Don't know exactly when. Miss Singleton will let you guys know when, okay? All right. Thanks for coming all the way down here.
Thank you, Your Honor.
Thank you. Miss Singleton, is one of the other conditions is that he resides with his mother. Is he still doing that, or is that another condition that needs to change?
He's residing at that address, which was actually his grandmother's address where his mother was living.
Oh.
So he's residing now with his grandmother and his father at that address.
Interesting. So he's sort of half complying. He's at that address, but mom's not at that address. Okay. And was that his father who was with him, or an older sibling?
That was his father and his little brother.
Got it. Okay. Thank you. All right. Can we bring Ms. Carlin out, please? All right, let's go on the record, please. This is 18 SC 162212, State versus, how do you pronounce your first name?
Hallie?
Hallie Carlin. Ms. Carlin is here in court with her lawyer, Mr. Ryan. Ms. Dilligard's representing the state. And Ms. Carlin, you are here because way back in April of 2022, so 3 years ago, I signed a warrant that alleged that you violated your probation in this case by getting arrested in March of 2022. So again, 3 years ago, for possessing some kind of drug and DUI in Dawson County. And also, you had not been doing real well with your community service back then. You are now in custody. I don't know if you were arrested for other things or if this warrant finally caught up with you 3 years later. But Mr. Ryan told me that he thinks you all have sorted this out. So I'm going to first ask Mr. Ryan if Ms. Carlin is admitting to the allegations in the warrant.
Yes, Your Honor, and I can give the court some clarity if it wants.
You're going to do that after. I need one answer. I forgot to ask Ms. Simpson how much time remains on Ms. Carlin's probated sentence.
Judge, she did 1 year, 8 months, 18 days.
Okay. Yes, Mr. Ryan, I would love for you to get me up to speed. What happened in the last 3 years and what Ms. Carlin has to say about these two allegations.
Your Honor, she received that charge. I instructed her to tell probation about that. She said that she did that. The charge just got resolved in Dawson County 37 days ago, which is when the warrant popped up on us. We didn't know the warrant was there.
Okay.
But we were in Dawson County. Dawson County, Your Honor, if the court knows, moves very slowly as well. It sits.
You say as well. You're not comparing it to Fulton County.
Sorry, Judge. Didn't mean to say that. That was a slip of the tongue.
Yeah.
In and of itself moves slowly. But once it gets started there and we had an arraignment, negotiated the case and got something worked out. And then as we met with probation, they told us about the warrant. They took her into custody. So I think, Judge, ultimately she was reporting by mail or by phone. She said she told her probation officer, and we sat all that period of time in the same house in the same circumstances and didn't find out about the warrant. It kind of took us by surprise too, because our probation was waiting to see what happened with the case.
So was Ms. Carlin in custody in Dawson?
No,
She was
sir.
out on bond, but when she pled guilty to these charges several years later, was it to a custodial sentence?
No, sir, Judge. It was the probation. It was only to the possession.
Okay, not to the DUI.
The DUI. And we thought it was Delta 8, but ultimately it turned out to be Delta 9.
Okay,
So it was we pled to that with a conditional discharge.
okay, and led right into a probation warrant.
Yes, sir. Went to
Okay.
meet with probation and didn't make it out of the probation officer.
Got it. So the 35 days that Ms. Carlin has been in, that's sort of it over the last few years. It's not that she was in Dawson for a year while things move slowly. She got arrested in March, bonded out pretty quickly, and then that case just lingered.
Yes, sir.
And in the same time, even though she'd been arrested and she says she reported it, while probation issued the warrant, there wasn't follow-up on that warrant.
Correct.
Okay. Okay.
We were in the same address, in the same situation, same house.
Sasha Lane.
Yes.
Okay. All right. Well, here we are.
Yes, sir.
Okay. What are you recommending in terms of a disposition?
Well, she's been in 30, maybe 37 days, including Dawson County as well, Judge. But the time, asking to allow the court to give her 30 days credit for time served, release her back to probation. I believe the fees have been paid up by her mother as best we could do that. Your Honor, the court president, remember this case.
I don't, but I'm interested. It's got a strange charge, and there was a co-defendant who did something a whole lot more serious.
Yes, sir. So
you can refresh my recollection.
The boyfriend who was driving the car, they met a gentleman. They were going to hang out with him, and she ran in to get something. A Quick Trip came out, and the boyfriend, unbeknownst to her, had shot the guy in the backseat and killed him.
That's right. That's right. She comes back out, dead guy in the car, and they drive and.
Well, he says, "You better drive."
Yeah.
And he makes her drive, and he kicks her out of the car. And she, within several days, told some people and ended up being a witness for the state.
Right.
But was forced to do that. Tell you all that to bring up to speed, but also to ask, probably my fault, I didn't do a better job. I think she's suffering a great deal from PTSD from that and probably hasn't done enough, asking the court to also consider maybe some PTSD or mental health treatment or some treatment to help resolve that issue. I think she's been somewhat stagnated and in a rut. She's got a 10-year-old daughter, mother, father here, boyfriend, got a bunch of people here. But I just don't think she's been able to move on well from it, Judge.
Okay. All right. Ms. Carlin, have you been working at all?
I've had a hard time, like, working. I kind of do assistant work from this lady I know. I just kind of like clean her house and stuff.
Sure. How many hours a week is that?
Just depends on if she calls me or not. I've just been having a hard time, like PTSD and panic attacks and stuff. So I was trying to apply for disability for a while for PTSD, but
When you say trying to apply, what does that mean?
I'm in the process. I have a law firm, I guess a disability law firm working on it. They just denied me my first time because they said that I'm really young, so they're trying to do it again. But yeah.
Okay.
She and her daughter live with her mother still.
Okay. Your daughter's in school?
Yes, she's in
What grade?
4th grade,
Okay. Where does she go to school?
Vickery Mill Elementary.
Okay. Is she doing all right?
Doing good.
Good.
She's a good kid.
If you were able to work more just because you felt a little better about yourself, et cetera, what kind of work would you do?
Well, I like working with animals. I went to school for phlebotomy, but it's been kind of hard to find a job with the record that I have. But yeah, I'd like to work with animals. I love animals.
Okay. So you're a first offender, which means when you say the record that you have, it's nothing that you have to disclose. I don't know if your lawyers got it sealed, so it may be if someone runs your criminal history, it pops up, but it's not a conviction. So when you're in a position to feel comfortable enough to apply for work or go back to school, I'm just going to remind you of something I told you when you pled guilty, which is a first offender is not a convicted anything. That's the nice part of being a first offender. Of course, you put it at risk when you get arrested for other stuff. But you don't have a whole lot of your sentence left. And if you can get through all that, it all can be expunged. But it already should be fairly invisible to people who might be hiring you.
I was gonna say something about that. Was going to get a job at this like cafe. My friend was gonna help. It was a couple of years ago, maybe like a year and a half ago. But I did my background check, and when they sent it back to me, it had all the charges, including the ones that they dropped. So I really, because I remember them telling me that it shouldn't show up, but
Right. But it did, and you saw it. Okay. Well, I'm not an expert in that area. I don't doubt you at all. There are steps that can be taken that restrict access to that. So you may want to talk to Mr. Ryan about that, because I know I'm asked sometimes to sign orders that seal the records off, other than the law enforcement. I mean, always, if you got pulled over, an officer should be able to look up, oh, you just know that Ms. Carlin got mixed up with this other thing. But to employers or academic institutions, they're not supposed to be able to see this kind of stuff. Or at least, I'm not blaming them for finding it. There are ways to pull it back so that it would only be seen by a prosecutor or law enforcement or something. But that's a conversation for you and Mr. Ryan and your family to have if you want to pursue that. Ms. Dilligard, what's the state's perspective on Ms. Carlin's situation?
Judge, I think council summarized the state's recommendation to the T. Our recommendation is to revoke 30 days. She's already done that on the condition that she get a mental health evaluation and any treatment that's prescribed. We would also be asking the court to order that she do a chunk of her community service hours within a time that's deemed appropriate by the court. That's all I'm saying.
Okay. Ms. Simpson, from your records, does it still show that Ms. Carlin's only done 2 of the community service hours? Where did you do your 2 hours?
I'm gonna be honest, but I haven't done the 2 hours. They gave me a list of where to do it, but they were all really far, and it's not that I don't want to do it. I just have issues being in large crowds of people that I don't know. I mean, I've found places that I can volunteer at nearby, like animal shelters and stuff, but I don't know what I can and can't do.
Okay. Have you tried talking with your probation officer about that? Hey, I found this animal shelter. I would like to volunteer there. And that person said, no, you can't, or that's a great idea.
So actually, they never gave me a probation officer. I had a probation supervisor, but the thing is, I could never get her on the phone. I could send her text. Once in a blue moon, she'd get on the phone, but she's not much help. No offense, but.
I'm not offended. You're just telling me what your experience is. Did you try texting your probation supervisor saying, what if I did community service at the Roswell Animal Shelter?
I didn't.
Okay.
But I can.
So go ahead.
I can.
Okay, I'm going to need you to be a little more proactive on that front. You very much can chart your own course with the community service. It doesn't have to be you're in a large crowd of strangers, or even worse, picking up trash on the side of a busy road. That's sort of the image people have of community service. You can suggest options, and as long as it's not working at your family's business to help them make more money, or I'm cleaning my uncle's house kind of thing, it's not family related. My experience in talking with probation officers is that they're very open. It just needs to be documentable so that you're not saying, hey, I worked 8 hours last week. But in fact, a supervisor from the shelter says, Ms. Carlin was here, these are her hours, et cetera. But if you're not working, that says to me, you've got time. And so it's harder for me to be comfortable that you've done none of the community service. That said, I'm also mindful of Mr. Ryan shared with me about what you've been wrestling with, and you went through something real difficult. We're going to make sure you get treatment for that. But you and your lawyer negotiated a pretty reasonable outcome for a pretty messy case. And it's important that you live up to your part of that bargain. All right. Anything you want to add, Ms. Carlin?
I mean, I know I messed up. I got up on the wrong foot and I'm sorry. I can't.
That's okay. I appreciate you saying you're sorry. I'll tell you, I'm much more interested in what the next year and 8 months will be like. This situation was 3 years ago, and you haven't been arrested since then. So that says to me, at a minimum, you stayed out of trouble. You may have just stayed at home in a dark room, and that's sad. We need to get you out and about. But this has been dealt with. So I do find that you violated the terms and conditions of your probation. I'm going to revoke 30 days of your probation. Actually, I'm going to revoke 1 month. It's easier, I think, if I denominate it in months. So I'm revoking 1 month of your probation. You'll get credit for the time you served. I'm reinstating your probation. So you're going to be back on probation when you get out. And I'm going to ask that it be active probation for the remainder of the probation, which means you'll be supervised the whole rest of the time. I am modifying your probation by adding 2 conditions. One is that you, within the next 2 months, have a mental health evaluation. If you've already had one, then you've checked that box. But more importantly, if that evaluation results in any treatment recommendations, whether it's counseling or medication or both, that treatment becomes part of your probation. And so if you say, I'm not going to these sessions, then I expect to see from probation a warrant that says, this is meant to help Ms. Carlin. And she's saying, no, I'm not going to do it. So it'll be a mental health evaluation and then any treatment that's recommended. They may say, nope, she's good to go. It doesn't sound like you're good to go. It sounds like you would benefit from some form of treatment. That's not my space, so I don't know what that would be, but hopefully it would be helpful. The other amendment to your probation is that you need to, within the next 30 days, you need to have completed at least 20 of the remaining 250. It sounds like you didn't do 2 hours. I don't know how you got credit for 2 hours, but I'm not taking them away. Whatever your balance is, within the next month, you got to do 20. And then it's another 50 every month after that, unless you get a full-time job. And if you get a full-time job, we'll ratchet that back, because I don't mean for you to be figuring out how to fit too many hours into the week. So we'll start slowly. You're going to get out there and it may be a little stressful, but I'm giving you a little time to figure out where I'm going to do those first 20. And then it's 50 hours a month for every succeeding month. And I like that cadence because then I don't have to wait 6 months from probation. If you do 20 the first month and say, I'm not doing this anymore, that very next month you'll have violated your probation because you don't do 50 more hours. Okay? And that's a little more than 10 hours a week of probation. You can do it all at once. You can spread it out, whatever works best for you and your comfort level, but you need to start doing it unless you get a job. And if you get a job and it's full-time, we'll figure out a way to do the remaining hours. It just doesn't have to be in such heavy bursts each month. Be proactive with your probation officer. And if your probation officer isn't calling you back, have your family reach out to Mr. Ryan. He can try, he can let me know, and I can get probation to be responsive. But it has to start with you. If you wait at home, waiting for a probation officer to let you know, here's where you can do community service, that's not probation's fault. Okay? Questions about any of that?
I do see a psychiatrist now. Does that?
You may have already taken care of all that. You and your probation officer are going to have a conversation about what you're doing for self-care on the mental health front. And if there's someone you see routinely, then that's the treatment that you need to continue to do while you're on probation. I'm not trying to add something new and different. If you're in good hands, I just want to make sure you stay in those good hands. And if that doctor has recommended that you take certain medication, that you're taking that medication. You'll just need to share with probation, here's what I do. I see Dr. Jones twice a month and I take this medication for depression. Okay. Then the probation officer, when she sees you next, is going to say, did you see Dr. I did see Dr. Jones. You taking your medication? I am taking my medication, whatever's going on. Okay. You don't need to reinvent that wheel. All right. Mr. Ryan, anything else on behalf of Ms. Carlin?
No, sir, Your Honor.
Ms. Dilligard? Ms. Simpson, do you need anything else for me? Or you got it for what goes in the revocation? She got it. Okay. Ms. Carlin, you may not get out today. I'll sign the order today, but if you don't get out tomorrow, call Mr. Ryan, have your family call Mr. Ryan, and then we'll figure out what the hangup is. I'm assuming there are no holds from Douglas County or anything like that. So you should be out sometime tomorrow at the latest. Okay, and you've got a place to go. You're going back to Sasha Lane?
Going back home, yep.
Okay, good. All right, I bet your dad will be happy to see you.
Yes, thank you.
All right.
Give excuse, Judge?
Yes, sir.
Probation.
You are?
How is mom?
Hey, Mom. Thank you for letting her stay with you.
I tried to get in touch with probation, and I got him on the phone, and then I got some text messaging back, but the past few weeks, because I was trying to find out what her balance was for her probation, and I texted different days and got no response. So I paid, which I thought would have been the right amount, and as a yes, but I have no idea. And like I said, she didn't respond to texts. And this is the Officer Smith, I think, whatever.
I have Gloria Williams, but that was in 22 who signed the warrant. I don't know if it's the same. Okay.
But there's no probation officer that you've ever had.
Well, that's her officer. I mean, I know someone called her supervision, but that's Officer Williams is a community supervision officer. And so that's the person to whom your daughter is assigned. And that's the person who needs to be more responsive to reasonable outreach. It may be if you text at 9 a.m, because this officer has, sadly, 100 people she's supervising, she don't get back till the next day, but never getting back is not okay. And that's where I encourage you to reach out to Mr. Ryan, and he can send me an email copying the prosecutor. And then that's what I need to reach out to a supervisor of the supervision officers to say, this doesn't work. You guys need to figure out something different because Ms. Carlin isn't getting the feedback that she needs.
Like a reasonable, once she's out, if she can't get in touch with somebody in a week and get a response, then we should go ahead.
You should escalate. Definitely if there's been no response within a week. Okay?
Okay.
Good. But yeah, the burden starts with your daughter. But if she's making that good faith outreach, in particular with this community service, where if there is a place she'd be comfortable and motivated to spend some time, let's get her there. Assuming probation says that's an okay spot. But if they're not getting back to you, we don't know if that's a good spot, and that's not okay. Okay?
I just wanted to bring that up because I wanted to get an answer before we got out of here.
Yep.
So we knew where we were going. Thank you.
You bet. Good luck.
Thank you.
You bet. You're welcome. All right, Ms. Rios. Let's bring Mr. O'Neill out, please. Palmer left already? He's such a short timer. Someone was using the bathroom. You had to open right when they're flushing? Hey, Mr. O'Neill. I'm confused. I'm Judge McBurney. I don't know if we've ever met before. I inherited the docket of Judge Reeder, who inherited the docket of Judge Downs. And you pled guilty to a theft by receiving case way back in 2016 or 2017, got probated sentence, and in 2019 did some things that violated your probation, got arrested by Atlanta police, got arrested in Cobb, et cetera. And so my predecessor signed a warrant, and somehow that warrant has just popped up now, but your probation's expired.
Right.
So I'm hoping that you are being held in jail for something other than this warrant.
Yes.
Yes, what are you in jail for?
I'm in jail for a simple battery charge.
Okay, got it. And it's a Fulton County case?
Yes, sir.
All right. Let me look up your booking number, and then we'll just make sure. You seem to know why, and that's good. We won't make you come see me again now that we've cleared up this part. 5583. Whoops. Yeah, I got battery and cruelty to children in the 3rd degree. You have a bond. Have you not been able to make the bond?
Yes, I can make the bond. I have a parole hold.
Okay, that's in here too, but that parole hold's not, what's that for?
Oh, that parole hold is for about. Yeah, I'm still on parole. The parole hold is for catching the simple battery.
Okay, you were on parole for what?
I was on parole for a 2020 case.
Okay, from Fulton or another county?
For Cobb County.
Okay, what kind of charges?
Attempted burglary.
Okay, got it. So the scenario is you're on parole, you pick up these new charges just recently, and you could post that bond, but why? You're gonna deal with your parole violation. So you're gonna go to Cobb and have that dealt with, and then you can post bond on your battery and you're out?
Yeah.
That's the plan? Okay, all right. I feel better then, because I was worried when I learned that your probation had expired, that somehow we were holding you on a warrant that is out. I'll make sure this warrant gets canceled. That's the probation warrant from 2019. And then I guess we'll get you transferred to Cobb County so you can deal with the parole violation. Okay? Any questions?
So that's all. That would do it for today, just for.
Yeah, well, I didn't know. When I get the paper, I'm like, all right, this looks like an old case. Wonder what he got arrested for. And I was looking at the warrant, like, man, this is so old. This was from May 2019 when you got arrested. Street gang activity, burglary. This is probably your Cobb case. That's your 2020 case.
Yeah, that was the 2020 case. The 2020 case is for Cobb.
Yeah, it's APD arrested you on a Cobb warrant for street gang activity, burglary, theft by taking, firearm, blah, blah, blah. And that was the basis for this warrant, but that's your Cobb case that you ultimately got whatever sentence you got and you're on parole for.
But the prison for that, and then
Got it.
And I just got
Okay. Well, good news for you. You're done with this 2016 case from Fulton County. You got the new charges in Fulton, but it sounds like you can make bond on that. You just need to go to Cobb.
Okay, so the probation that I was on, that probation is terminated.
It's not that it's terminated, it expired. You've completed that sentence. Correct.
I had completed the probation. I was on parole for 2 months, and I had completed the rest of the remaining of the probation.
You did correct.
I had seen the probation violation for the charge, and I was like, man, this probation is over with. I completed that probation.
See, you knew that, I didn't, but now I know that, and I won't drag you back here. And maybe you stop getting in trouble, and you won't have to worry about why you're in these different places.
Yes, sir.
All right, that's on you. All right, Mr. O'Neill.
All right.
See ya. Ms. Simpson, what do we need to do? Is there a warrant cancellation? What's our due out so that this doesn't grab him again?
Well, I can file because that warrant is the old warrant, so it won't have to be them, so. You know, it's not even in our system anymore.
Is it in any system? Okay, then maybe there's nothing we need to cancel. How did he get on this calendar then? All right, Ms. Nelson and I will take it up.
Because all we have is the parole warrant, so.
Okay. And I see that too, and he owns that one. Yep, I'm going to Cobb. All right, I'll hold on to that. Mr. O'Neill is done, Carlin is done. That just leaves Edwards. So before we bring Edwards out, the two warrants I have are technical violations, but I'm hearing you talk about burglaries and stuff. Oh, different case. All right. Hey, I appreciate you working ahead like that. How much time is left for the two Edwards cases?
2 years, 9 months, and 20 days.
Same for both cases?
Yes. And it also has a whole.
Oh, Cobb is a popular destination. No, that's where people are going. All right, Ms. Rios, anything else before we bring Edwards out?
No, we can bring her out.
Edwards.
They've been busy. They've been busy. That new chart that they picked up.
What's wrong with, is it important? Is
That
that,
arsenal?
I looked
it up. No, the arsenal was here.
This is for Edwards?
Yeah. They lit some stuff on fire while he was in jail waiting for this case. Where'd they get it? How they sell it?
Hey, Ms. Edwards, if you would please come to the podium. Give me 1 second. I'm just pulling your file up.
Address information to pad if you want to go there. For services.
All right, let's get on the record. We have two cases for Ms. Edwards. It's 23 SC 187338 and 24 SC 000511. Ms. Edwards, for both these cases, you've got a little less than 3 years remaining on your probation. And I have two warrants that I signed in September of last year, one for each case. And they allege the same thing, which is that you effectively absconded, meaning you were not findable by probation. You weren't at the address you had given them. They couldn't track you down. You missed what they call a virtual interaction. And one of the key parts of probation is staying in touch with your probation officer, and probation officer did her best to track you down and couldn't do that. So it's a technical violation, but it's a, where is Ms. Edwards? And they shouldn't have to ask that. Ms. Rios, is Ms. Edwards admitting to the allegation in each warrant?
Yes, we're stipulating.
Okay, got it. What is your recommendation as to how we move forward?
To revoke 60 days and continue her on probation. I did talk with her mom, and her mom said she can stay with her. She was supposed to be on Zoom. I'm not sure if she is
She may be. We've had a couple of very patient people who've been on for a long time. I don't know which is which. We've got an iPhone, JE, and BP's iPhone. Is any of those your mom? Ms. Edwards?
The one in the purple shirt.
I don't see a purple shirt.
A striped shirt that's blue, black, white, and purple. Yeah.
Oh, right there. Okay.
Yeah, left.
There she is. And let's add podium. Okay.
And so they were thinking to, I believe they're in the process or need help trying to get her benefits for disability for mental health. And I recommend the PAD program. I think Ms. Ross already did let them know that she would be coming once she take care of the Cobb business. And I gave Ms. Edwards the address so she knows where to go when she's done with Cobb to get more services. But her mom says for time being, she is able to stay at her house, and I do have her mom's address.
Okay. PAD typically doesn't say, yes, you can use us as a condition of anything.
Yes, no, I'm not asking for it to be a condition. I was just letting you know that she, I spoke with her mom, and that PAD would be a good place for services, that she needs additional help. She expressed to me with her daughter, and PAD will be able to help with that.
Okay. Got it. One of these cases is a Judge Newkirk case. It was one of these our case? Let's see, 187. Let me look that one up. Yes, okay, one was ours, the aggravated battery, aggravated assault, but the other case was a Judge Newkirk case. So let's look at this disposition. Ms. Edwards got first offender from Judge Newkirk. And here. Interesting. They both say Newkirk. I wonder if he somehow covered for the pleas. He signed them, but they're in this division. Oh, well, here we are. So revoke 2 months, credit for time served, continue on probation, and at least initially reside with mother.
Yes, Your Honor.
Okay. Anything else?
No, Your Honor.
All right. Ms. Edwards, you have a hold out of Cobb. What's that for?
I don't know.
You have no earthly idea, or? Okay. Well, I guess that'll be an adventure. Ms. Dilligard, what's the state's recommendation in Ms. Edwards's cases?
The recommendation is to revoke the 60 days.
Okay. And any amendments to the conditions of probation? In one, it was stay away from 2 officers. And then this one is you're employed, anger management, stay away from Dontavius Lanier, and don't display gang signs.
No, Judge, but we would ask that you add the condition that Ms. Edwards completes her anger management course within 60 days of release.
Okay. Have you taken care of the anger management course yet, Ms. Edwards?
No.
No? Any reason why?
No.
Okay.
Judge, there has to be a question about outstanding charges. There's 4 pleading to.
Say that again?
4 pleading and.
Okay. It's 4 different charges, or that's basically it's fleeing in a.
She is considered to be a part of a car speed chase that took place in Miami.
Okay. Got it. All right. So Ms. Edwards, here's where we are. You are partway through your sentences. You seem to not be super invested in probation. Probation isn't something you have to love, but it's something you have to do. You got a first offender disposition for your two cases together because you pled to them at the same time in front of Judge Newkirk. And that is a pretty good opportunity that you got. Right now, I'm not hearing the state say that they're seeking to revoke your first offender status. I'll leave it in place, but I got to tell you, if we are together again because you became hard to find, you didn't do your anger management, or I'm happy to deliver a wake-up call. I don't know that we need to go through that process, but you need to stay plugged in and make sure you're taking care of the things you're supposed to take care of. Before you got picked up on these warrants, were you working? No?
No.
When did you last work?
It was a minute ago, but I do hair on the street.
Okay. I don't mean you got to go work in a factory and clock in, but if you're doing hair on the street, that's work and you get paid for it. You do that now or, okay. What do you say that is typically in a week, that you do 1 a week or 10 a week? You're busy all the time.
It varies.
Okay. What's a busy week look like?
At least probably like 7, 8 people.
Okay. All right. Do you have any questions about anything?
No.
No? All right. Well, Ms. Edwards, I find that you violated your probation by absconding, not being where you said you'd be, not returning calls, etc. I'm going to revoke 2 months of your probation, excuse me, give you credit for time served, and continue you on probation for at least 2 years of the remaining balance. That'll be active supervision. And you have 60 days to take care of the anger management course. It's a class. It's not like you need to go 6 times a week or anything like that. And you have a place to stay. You're going to stay with your mom initially. Is that correct? What's your mom's last name?
Reed.
Reed?
Yes.
Ms. Reed, can you confirm that Ms. Edwards can stay with you? You're on mute.
Hey, this is one Edward's sister, and my mom, she don't know how to work her mic. So yes, I can confirm for her that her last name is Reed.
Okay, but can you also confirm that your sister can stay with your
At
mom?
my mom's, yes.
Yes. Okay. Thank you for serving as audio double for your mom.
You're welcome.
Appreciate that. Okay. So Ms. Edwards, you've got good family support. Take advantage of that in a good way. It looks like they're there for you. I'm wondering if, and maybe something like this is already in place, if it wouldn't be a bad idea to add a condition of getting an evaluation and treatment. Do you have an objection to that?
Is that okay with you?
Yes.
I think that's appropriate, Your Honor.
Okay, so I'm adding as a condition of your probation that you get a mental health evaluation, and if any treatment is recommended to help with depression or anything else, that you follow that treatment. I think that's it. Ms. Rios, anything else on behalf of your client?
No, Your Honor, thank you.
Ms. Dilligard?
Nothing further, Judge, thank you.
Ms. Simpson, anything else? Do you need that address, mom's address? Do you know your mother's address, Ms. Edwards, or do we need to get it from someone on the call? You know it? What county is it in?
Unfortunately.
Okay, all right. Ms. Simpson will go get that from you. We don't have to get it on the record. But that'll need to be where you stay at first. That's not the Ravenwood Drive address? No. The other address I have seen is on Old National Highway, not your mom's place either? Okay, all right. Well, you give the address to Ms. Simpson. And you should be released to your Cobb hole in the next day or two, and then you'll be heading up to Cobb for this fleeing and attempting to elude charge that they've got you on. All right? Anything else from you? No? Well, good luck with everything. We're good? Well, I appreciate folks from Ms. Edwards' family staying on this call for so long. I think some of you joined first thing this morning, but we weren't on till this afternoon's calendar. All right. I think that's it. Okay. All right. Well, let me release Ms. Hicks. Thank you, Ms. Hicks, for your help today.
No problem, Judge. Thank you.
Take care. All right. That is that. I will see other folks tomorrow.